numbers are switched off, my lord.
So then it's all the more there is a risk of abduction. Definitely a risk of abduction. A report filed by the police today be kept, a report filed on behalf of the police authorities today be kept on record. First off, it transpires that upon investigation on the basis of a missing diary initially lodged by the petitioner, the police have come to the preliminary conclusion that the petitioner's wife, what is the name of the lady?
Sujata Borman.
Namely, Srimati Sujata Borman had eloped with one Taposh Kundu. Taposh Kundu. For sub next para, however, learned counsel for the petitioner points out that subsequently on June 20, 2025, a specific complaint was lodged by the petitioner alleging that his wife has been abducted by the said Taposh Kundu himself. So moreover, it transpires that since the lady went missing, her phone number has been switched off. Even learned counsel for the state, on the query of court, submits that the lady cannot immediately be traced out in view of her mobile phone being switched off. Next para, however, we do not find, we find substance in the contention of the petitioner inasmuch as since subsequently the petitioner has lodged a specific complaint against the said Taposh Kundu on a cognizable offense, the police ought to have registered an FIR immediately. Next para, moreover, it is well known that the mere fact that a mobile phone is switched off cannot deter the police from tracing the location of the missing person in view of the latest technology available. Accordingly, the officer in charge, officer or inspector in charge?
Officer in charge of Pundibari.
Of?
Officer in the Pundibari police station.
The officer in charge of the Pundibari police station is directed to ensure that a first information report is immediately registered on the basis of the complaint of abduction lodged by the petitioner during the course of this day. Next para, thereupon, the police will make all endeavor to trace out the missing Sujata Borman. Missing lady, Srimati Sujata Borman, and file a preliminary report on the returnable date in that regard. The matter be placed in the list under the heading to be mentioned on July 30, 2025 for furnishing further report by the police authorities. Try to trace out. We are adding a line. In the event the lady is traced out, the police shall also take an appropriate statement under section 164.
That is 183 of the BM.
160. Oh, yes. What is the current provision? Under section 183 of the BNSS.
Extremely good.
Thank you. Thank you. Thank you.
Item 2, my lord, when the POCSO case I start, two them are not delivered upon the, but I am for the statement.
Yes, at least our invitation letter had its effect. Yes. In your chin, Mr. Prabhu. Yes.
I have sent, but service not completed.
Service on victim. Oh, defect. Very well, then when should you keep it? Tell us. Next circuit, next week. Learned counsel for the.
State, state also have for the officer.
Very well, direct the state. Learned counsel for the petitioner submits that the victim could not be served a notice of the appeal. The victim stroke defect, she was the de facto complainant. That the victim has to be served or the de facto complainant. The victim and or the de facto complainant could not be served in the meantime. Next para. Accordingly, on the prayer of the petitioner, the matter is adjourned till July 29, 2025 to enable the service to be completed. In the meantime, the state shall also take measures to ensure that service of notice of the appeal is completed on the de facto complainant. Thank you. Thank you.
The appeal being in connection with POCSO, victim has not yet served also.
same order.
Monday.
Monday will do. Monday,
I believe Monday will then.
তাহলে returnable date January 28. Mr. Chakraborty, here also the state will.
Wait,
July 28 এটা। Yes, Mr. Sengupta.
Mr. Appeal for the appellant. So,
What is the charge? Offense, what is the offense?
convicted under section 302. 302, 394, 364A, and 201, and 34 of that.
Right.
And sentence, life. Well, the trial started, he was arrested on 30th, 2nd February, 1st February 2013.
Twelve years in custody. Any previous application for bail?
Trial was not completed in 10 years. Then, my lord, an application was moved before the honorable court. The honorable court was pleased to grant bail after considering all materials. At that time, evidence of all the witnesses was completed. Only argument was due.
Bail was granted
Bail was granted.
during the trial. No,
Situation, my lord.
Bail was granted.
then what happened?
Thereafter, my lord, he did not jump the bail. Thereafter, argument completed and judgment was delivered.
Thereafter, he was taken in custody again.
He was taken custody.
When did that happen? When was the judgment passed?
My lord,
When was he taken in custody again?
my lord, it was taken on custody when the judgment was delivered.
So how long has he been in custody in total? Minus the bail?
11 years, more than 11 years.
Have you annexed that bail order?
Yes,
Lordship, it
yes,
is.
yes, yes.
Page
164, that page 164. P2, annexed P2.
Well, running page
164,
164, my lord.
Running page 164. Not pandemic situation.
Bail was granted during the argument.
Let us hear them. Yes, let us hear them. Yes, yes, Mr. Whoever.
Bail was granted during at the stage of argument, as because for long detention. But at present, Lordship, the presumption of innocence is not there, as because he is
Convicted now.
convicted.
But the long period in custody?
More than 11 years.
He did not jump bail.
Learned counsel for the petitioner submits that the petitioner was, petitioner was granted bail at the stage of arguments in the trial. First of next para. Thereafter, the petitioner did not jump any of the conditions of bail, full stop. However, after being convicted, he was taken into custody again. Full stop. It is submitted further that the petitioner, the total period for which the petitioner has been under incarceration is more than 11 years. Full stop. Although a life sentence was granted, it is contended that since the appeal may take some time to be heard, bail be granted. Full stop. Next para. Learned counsel appearing for the state, by what would be say? Oppose the bail. Oppose the prayer for bail and point out that in view of the conviction, the initial presumption of innocence on the ground of which bail was granted is now lost. Full stop. Next para. However, keeping in view the long period of incarceration already suffered by the appellant and the fact that the appeal may take some time to be disposed of, we are inclined to grant bail to the appellant stroke petitioner. Full stop. Accordingly, the appellant stroke petitioner be released on bail upon furnishing a bond of rupees 20,000 with 2 sureties of like amount each, one of whom must be local, to the satisfaction of the trial court, to the satisfaction of the additional chief judicial magistrate Siliguri, district Darjeeling, subject to the condition that the said petitioner shall appear, as and when so directed by the appellate court,
Additional chief judicial magistrate Siliguri.
Siliguri, yes. Siliguri district Darjeeling. We say. Shall appear as and when directed to do so by the appellate court, and shall not intimidate any of the witnesses or try to tamper with the evidence or the records of the appeal in any manner. Furthermore, the petitioner shall not leave the territorial jurisdiction of the Matigara police station, except for the purpose of attending the appeal, if so directed, before this court. Moreover, the petitioner shall report to the officer in charge, Matigara police station, once every month.
I'm good.
Thank you.
Keep your minutes. Well, I am for the appellant, my lord.
Yes, Mr. Shabud.
We are looking for NCB, Lordship kindly fix this matter Monday.
Why?
Lordship DSGI appearing in this matter.
Sir,
DSGI appearing in this matter and record we need.
bail matter, you should prepare yourself.
Bill
10-year
NCB. NCB Lordship.
What was the offense?
NDPS Act, 10 years imprisonment. During course of trial, he was on bail. During
Total period of custody?
total period of custody.
Not
2
much.
years, 150 days, my lord. He was on bail, my lord.
Let him come. Your learned friend will be embarrassed otherwise if we grant bail. On the prayer of the state, on the prayer of the respondent authorities,
NCB.
and respondent authorities, the matter is adjourned till July 28, 2025.
Item number 7.
For item number 7 for the appealing, my lord.
Item number 7, Miller, I am for
Bill,
the
my lord.
appealing for the de facto complaint, appear for legal aid service, Miller. Paper book already been ready, Miller, kindly,
Let him move the bail application first.
Miller, let me see the evidence, Miller. paying
Let him move the application first.
Saying
He is a petitioner. Yes.
Yes, sir.
You're paying for not today.
Miller.
You're not asking for time.
I'm paying time, Miller.
Why?
To see the Miller paper book and see the evidence of the
It has not been prepared.
prepared, Miller. Paper book has been prepared, Miller. Your lordship.
Now,
Paper book already prepared,
now
Miller.
it has been prepared. What are the circumstances? Let us hear them. Yes.
I am in custody since 6 years, 4 days.
All right.
Earlier one.
Let me finish.
Yes.
This is a renewal of the prayer for bail.
What is the offense, Mr. Bhamu?
6 for POX. 6 of POXO, I have been convicted for 20 years.
What was the age of the victim?
Age of the victim was
About
9 years. But
and you were at the time?
I am at the time 19 years. And so for the medical evidence is concerned, it is completely contrary to the prosecution case.
But
No,
you have
it
been
is-
convicted.
Hello?
Now that those arguments will be subject matter of appeal.
Rely on judgment purpose on the Supreme Court. There is the wrong pendency of the appeal. The sentence may be suspended. Appeal was admitted in the month of November 2024.
November 2024 is not so long, sir.
Actually,
And paper books have been prepared in the matter.
there is
Earlier-
a possibility of immediate.
No, POXO, but the victim may be at risk.
Miller, kindly see last talk.
I have informed the victim.
No, not about informing. They may be at risk.
Imposing any stringent condition, my lord,
When was it last? January this year.
January.
This point already been taken into consideration by the coordinated bench. Honorable
No,
Court.
but at
We
that
will refuse bail, but direct the appeal to be listed. The appellant contends that the appellant has already been in custody for about 6 years, 4 days. First up, it is submitted that the appeal was admitted in the month of November 2024, but has not yet been heard out. First up, as such, the long pendency of the litigation ought to entitle the petitioner to bail. First up, in support of such contention, learned counsel cites such and such versus such and such reported at AIR 1999 SC 1859. Push up next para. It is submitted by learned counsel appearing for the de facto complainant that a previous application for bail filed in connection with the appeal by the present appellant was rejected on January 21, 2025. Push up next para. Upon a perusal of the said order, we find that the coordinate bench recorded that the nature of the offense was such that the bail ought to be rejected. So it was further recorded that PW2 was the victim and she stated that she had gone to her uncle apostrophe's house where the appellant had come and was and slept with his cousin at night. Subsequently, the appellant committed rape when the victim tried to scream, upon which the appellant told her that he would treat her in a soft manner and offered money to keep the victim quiet. The said deposition, it was recorded prima facie, was corroborated by the other witnesses, and from her version, it appeared that the victim was unable to resist the sexual act for which she did not suffer injuries. Next para, although it is argued by learned counsel for the appellant that there is discrepancy in the evidence, since the trial court has already convicted the victim and such arguments are sub judice before this court in the appeal itself, we are not inclined to grant bail, more so since the last rejection was only a few months back on January 21, 2025. Next para, be that as it may, since we are apprised that the paper books have now been prepared, let the appeal itself be listed for hearing on July 28, 2025. However, in view of the above circumstances, CRAN 2 of 2025 is dismissed.
Lord, I am for the appellant.
Yes.
Lord, the case was initially it was under 302. Lord, conviction is under 302.
Yes.
Lord, the petitioner, Lord, has been sentenced to imprisonment for life. Lord, he is in custody for almost 834 days. Lord, that is 2 years, 4 months approximately.
How many days?
Lord, 2 years, 4 months approximately.
Yes, 4 months, 834 days.
Lord, the most clinching circumstance, my Lord.
That means you are granted bail in the trial.
No.
Or
No.
trial took place early.
Yes. The period of
302.
trial was shown. 302. Yes.
Yes.
Lord, the deceased lady is the wife and he is the husband. Now, my Lord, basically, my Lord, from the entire case record, it transpires that it was a case of suicide. But ultimately, my Lord, 302 was the case was started under 302 as per the complaint submitted by the father-in-law of the appellant. Now, my Lord, the most clinching circumstance in the case is, my Lord, the mother of this appellant was present in the adjacent room when the entire incident happened. But she was neither examined by the police, nor she was made a witness, nor, my Lord, her version ever came on record, my Lord, during the course of trial. My Lord, will find
Mother of the victim.
mother-in-law of the victim and mother of the appellant.
Mother of the accused person.
Mother of the accused person.
That might not have been relevant.
Lord, she was present since in the same house, adjacent room.
Who are the prosecution witnesses? The others, neighbors?
Neighbors were there and relatives were there. Lord, page number 13. Lord, two prosecution witnesses, Lord, who happens to see, Lord, as per the prosecution case, who happened to see that there were some incriminating materials in the hand of the appellant at the time of when they entered the house. Lord, they turned hostile during evidence. Lord, will find page number. Lord, another thing. Lord, the case of the prosecution was that, Lord, the lady was assaulted with bamboo sticks, and Lord, he was apprehended on the day of the day of the occurrence. After 2 days, when he was arrested, Lord, after.
No, the appeal paper books are ready.
No, my Lord, this is a new matter. My Lord.
Yes.
And I'm Yes,
Dr. Chaudhary, complete.
Lord, 2 days thereafter, he was arrested. He was taken back to the place of occurrence and my lord, then two bamboo sticks was recovered as offending weapon. Now, my lord, the most important thing in recovery of offending weapon is, my lord, the disclosure statement given by the accused person. My lord, that is relevant under section 27 of the Indian Evidence Act. Now, my lord, there was no disclosure statement recorded at all. And my lord, simply after 2 days, my lord, two bamboo sticks were recovered, saying that these were the offending weapons used by the by this appellant, my lord, to assault.
You may have a good, pretty arguable case in the appeal, but Dr. Chaudhary, at this stage, it would be too early. You are a lifer and 2 years, 4 months only.
Look, that's
Not
right,
much
but
of a time.
it will take some time, my lord, to hear the appeal. My lord.
Understood.
Last
Understood.
this week only, your lordship has
Admitted.
admitted the appeal.
Understood, Mr.
So,
Dr. Chaudhary. Well, let us hear the state, yes.
My lord, 302 is concerned, my lord. Kindly, my lord, appreciate, my lord, running page 33. This is a PW7 deposition of the doctor, my lord. This is a highly corroborating with the prosecution case.
You did not recover the offending weapon or the person next next room.
There, multiple injury. Kindly see, my lord, the deposition of the doctor.
Yes, but we have to connect the
Legal marking.
but you have to connect the accused for the convict to the offense.
My lord, PW2 is the neighbor, my lord. She rushed to the spot after the committing murder. He said the dead body lying with the.
Why were the weapons not recovered at the spot? That is his case, Dr. Chaudhary's case.
Yes, my lord, I have just.
Can you just check up the Caesar list or something? Any bamboo sticks can be put subsequently. And we Bengalis are famous for that.
On the basis of the leading statement of the accused, my lord, the offending weapon has been recovered.
From the same house,
My lord.
he was arrested, nabbed by the police, but the weapons are not. সাবজেক্ট ম্যাটার ব্যাকই লেগে যাচ্ছে একটা কোর্ট তো কনভিক্ট করেছে অর্জুন জানে সেটা করে দিন ইউ আর নট গ্রান্টিং yes Mr. Chakraborty, you are not granting
my lord, page 47 once, the leading statement part.
since we have observed against you, we'll look into page 47. Yes,
Well, that is the cross-examination of the investigating officer.
yes, subsequently recover. We get your point.
No statement was recorded on 11th court. Lord, that is
Might be arguable, good arguable case in the appeal.
Good argument case for appeal.
Life at 2 years, we are a bit hesitant. Yes, Divya.
Yes, yeah. Petitioner is a convict in session case number 13 of 2023 for an offense under section 302 of IPC. The said sentence, said conviction and sentence has been challenged in this appeal. Learned advocate for the petitioner submits that a petitioner is in custody since 2 year and 4 months.
4 months.
2 year and 4 months. And there is no chances of early hearing of this appeal. So he prayed for release of the petitioner on any condition. However, the learned advocate for the estate vehemently opposed this prayer, citing the nature of injury as appears from the deposition of PW7, the autopsy doctor, Since the allegation, since the petitioner is convict under section 302 and he has spent 2 year 4 month uh, in custody and not custody, in jail. It would be premature to grant bail. However, the department is directed to prepare paper book of this case as early as possible so that hearing of this appeal could be concluded within short span of time. Accordingly, the petition, the instant petition is rejected. There is,
That's
Item number 9.
Yes, Mr. Mishra, what is that? What is section 64 of the BNS Act?
376.
376.
9 months. How dare you?
Try it,
Based on one of self-contradictory statement, one of the indispensable part is that even one of the victim deposition reflects some substantial self-contradictory positions.
How?
One of the
Like,
Already
FIR
convicted.
registered after 10 days from the date of alleged incident.
what was the age of the victim? What was the age of the victim?
One of the victim was one of the married lady, 35 years.
That might have been a reason for the delay. Married lady may be hesitant
Lordship kindly
because of the stigma and all.
absolutely self-contradictory. Even one of his husband is the one of the PW2. His statement also contradicts with the.
What could be the reason to frame you? Is there any prior enmity or something? No. So why should a person be?
Because the appellant happens to be one of the neighbor, out of animosity, the allegation. has been
Rape
made.
charge against one's own wife. Rape charge against one's own wife, he gives evidence also. The lady I can understand.
My lord, the incriminating depositions against this accused is PW1 and PW.
We'll first see the mitigating deposition,
Yes,
then
yes,
see the
yes, yes.
incriminating. 56. ওইটা তো ইয়েতে রয়েছে ডিপোজিশন এতে রয়েছে do you have a copy? এটা ছিঁড়ে ডিপোজিশন
I have got the paper.
this shows the deposition. Whose deposition first, Mr. Mishra? You just remember the incriminating page of the deposition.
PW1 and PW6 lordship, and mitigating factor is PW7.
Very well. Let us see 7 first. You are thorough with the matters.
I have. Yeah, and
No, we are looking into the. Acha, give another copy. Yes. Yes. Which one do you want to point out?
They start from.
Be quick, Mr. Vishnu. Only a bail application. Yes. Be quick.
Yes.
I am the defective complaint. But the incident occurred, paragraph 2, the incident occurred on 23rd of October at about such and such in my house, specifically beside my house, while I was taking bath on the tube well. At that time, Buri Bormo, who is my neighbor, approached me from the backside and grabbed me and dragged me to the nearby Kali temple and took me to the backside of that temple, and there he committed rape upon me against my wish. The said accused is present in court today, such as I shouted and hearing my hue and cry, my brother-in-law, within bracket husband brother, Deepak Bormu rushed to the spot and at that time the accused triggered. I informed the matter to my husband over mobile phone. After 10 days of the incident, I lost a complaint at Shadow Women PS Coachwear in writing. He herself, my lord,
Husband evidence is not so important
Yes,
because it's hearsay. Let us come to 3.
Under PW
Yes.
six is the brother, my lord. PW six.
Also, yes.
Yes, my lord, that is important.
Where is the contradiction in the victim's evidence?
he said that, my lord,
She, yes.
She stated that in paragraph number 3 that.
What do you want to approach? Drag.
Incident happened at Calcutta.
Right.
Kindly come to, my lord, the next page.
Yes.
Nearby Calcutta,
The
not.
cross-examination.
Backside, back.
The cross-examination.
Crossing, yes. Which paragraph?
My lord, paragraph 2. At that time, none were present at the house of both of my brothers-in-law as the children went to the house and the elders went to the field. My lord, she stated in her, my lord, examination in chief, my lord, that, my lord, the brother-in-law, after hearing, my lord, his hue and cry, my lord, rushed to the spot. In her cross-examination, she stated, my lord, that no one was present. My lord, number 2, my lord. There is a road running through the front of my house and vehicle and people pass through the road. Not until and unless, my lord, I go through the depositions, my lord, I may not be.
We,
able to-
this at the, because one court has convicted at this stage, at the bail stage, no. Unless it's very glaring. This is subject to interpretation because she says also that none was present in the house. Court must have considered something.
The PO has been shifted, my lord. My lord, with regard to, my lord, the place of occurrence, my lord, everything has been, my lord, contradictory.
Yes, what do you say?
My lord, PW one and PW six, my lord, evidences. are
PW1,
corroborating,
what about the contradiction pointed out that
Yes, my lord. It is
although
true.
she says none was present in the house,
Yes, and she has shifted.
but
that
all the
evidence
elders went to the
cross-examination.
field, she
Yes.
says.
And
The
And
victims,
Let them submit,
And
yes.
similarly, from the evidence of PW six also, lordship, in the chief, my lord, whatever stated in the FIR, my lord, he has stated, but in the cross, my lord, he has slightly changed. I cannot say the dates of the Durga Puja because he's the only reliable witness. And kindly come to PW seven of the doctor, lordship, because this is the most important evidence, lordship.
Yes.
The evidence of the doctor.
no internal injury of the private parts.
Let us see.
31-year-old lady.
Yes.
So that is what I was telling, my lord. Incriminating witnesses are PW1, PW6, and mitigating factor is the PW7, lordship.
My lord, the victim stated that, my lord, the alleged incident occurred.
Because others are all
There is a
hearsay
kind of-
evidence.
If there is no internal or external,
Investigating officer.
wait. No internal or external injury. Rape, 31-year-old.
That is what I was telling, lordship. Mitigating factor is PW7.
Mitigating factor, arguable case কিন্তু করা যাবে না তো। একটা কিছু রাইটার একটা রাইটার দিয়েছি যে ওই ভিসিনিটি অফ ভিকটিমে কোনোভাবে বা তার উইটনেসদের কোনোভাবে অ্যাপ্রোচ করে চেষ্টা করবো ওইটা যেটা Mr. Lakshmi, we are granting bail. The present application for bail has been filed in connection with an appeal. First of the allegation against the accused is of rape. Of the appellant is of rape. First of next para, learned counsel for the appellant seeks to point out several discrepancies in the evidence of the prosecution witnesses. First of, for example, whereas in her chief, the victim herself, as PW1 stated that there was that her brother-in-law came rushing to the spot upon hearing her hue and cry, she has stated in her cross-examination that at the time none were present at the house and both her brother-in-laws as well as the children went to school and the elders went to the field. Full stop next para. Moreover, we find from PW7, the doctor, that in cross-examination, the doctor admits that she did not find any internal or external injury on the private part of the victim, which makes out an arguable case in the appeal, since the victim lady was over 30 years of age at the relevant point of time, and the total absence of internal or external injury might be a mitigating factor in the prosecution case. Push up next para. Accordingly, we grant accordingly, CR this is CRAN 1. CRAN 1 of 2025 is allowed, thereby granting bail to the appellant on condition that the appellant shall furnish bond of rupees 10,000 with two sureties of like amount each, one of whom must be local, and shall not attempt to tamper the evidence or approach the witnesses and or intimidate them in any manner whatsoever. Full stop. Furthermore, comma, the appellant shall not leave the territorial jurisdiction of his residential police station during the pendency of the appeal without the leave of this court. Full stop. That apart, comma, as a further condition of bail, comma, the appellant shall not, comma, in any manner, comma, try to contact or approach the victim or her near relatives and stroke or the witnesses in the case in any manner whatsoever. Full stop. This much. না প্রসিকিউশন ঝাড় হয়ে গেছে একটা যদি ইন্টারনাল ইঞ্জিনিয়ারিং না থাকে তাহলে কমপ্লিসিটি থাকে ধরা পড়ে গেছে মানে একটা স্কুলে হতে গেছে ধরা পড়ে একটা ইন্টারনাল এক্সটার্নাল ইঞ্জুরি নেই, কোনো রেজিস্ট্যান্স নেই, রেজিস্ট্যান্স তো থাকবে, হ্যাঁ সেটাও হতে পারে। ইয়েস ইয়েস মিস্টার সাহা। All right. 498, you're the husband. You're in custody for how long? 5. What is the sentence? Life. What is your mitigating factor? It's in appeal.
Father of the victim lady who came to know from the police at night at 3 a.m. on 21st of August 2022 that his daughter has been murdered and he has been asked to come at the police station.
So hearsay.
Yes. Subsequently, FIR was registered by the defendant complainant at 8:30 p.m. AM, sorry, in the morning of the same day. Subsequently, the duty officer who has come before the trial court and deposed that the appellant himself had surrendered before the police station at the midnight of 2:30, and he immediately asked the police officer in charge of the same police station what to do about this thing, and accordingly he made a GD entry. That has been used as a confessional statement, and on the basis of this particular confessional statement, the conviction has been handed down. So the charge sheet has been submitted under 498A and 302. However, the appellant has been convicted under section 302 only, and 498 he has been acquitted from 498A. So now the case is this, Lordship. They have in the charge sheet total 14 witnesses have been cited, but 17 witnesses have been cited, but they have examined only 14 witnesses. Now, out of 14, 164 statement has been recorded. Out of all the 364 statement recorded, that is PW 1, 2, and 3, all are hearsay. That has been also in.
What about the others?
Yeah, the others 161 others witnesses
4
are all hearsay. Because none.
If all of the prosecution witnesses are hearsay.
Yes, except apart from the formal witnesses. Doctor, police, apart from this, all the informal witnesses.
No, but here maybe at that time of the night somebody might not have been present. Nobody might have.
None.
And he was they are spouses. So
the crux of the issue is this: according to the prosecution story, when the appellant and his wife and the 8-year-old boy was sleeping inside the room. The entire incident has happened, but the interesting thing is that that child was never made a witness, and his witness has been withheld deliberately. I don't know. Now kindly see the offending witness, that is the hammer, has been purportedly used for the murder. That has not been sent by the police according to the charge sheet. That has been categorically stated that hammer has not been sent, which was with the blood stain. And only the wooden bar that has been sent for the examination. The examination report came up.
Wooden bar means the handle of the hammer.
Yes, and only the bird of the wooden bird has been sent, which has came up with a report that he thoroughly examined and could not detect any chance of print on it. Hence, no question of comparison arises and returning the document so and so.
No one else was present there, only the 8-year-old child. The obvious, the dots are connected.
Lordship,
No one else was present there.
only the child was there, but child
Only
has,
child was there, this person was there,
Yeah.
she died.
yes,
She could not die of her own by hammer hit, by being hit by a hammer.
but the
So
child.
there are connecting dots here.
Lordship, no, the child has not been examined. Now, Lordship, kindly see that the most interesting thing is this, that
Medical
That-
report is clear. I mean, against you. Medical report is against you.
no, there is an allegation of by assault by the hammer as well as strangulation. But so far the PM report examination, PM findings is there. There is no sign of throttling. Sorry, no sign of throttling. Now, number two. Number three is the most stunning issue is this, Lordship. The external, the extrajudicial confession, that is the particular GD is citing, that has been recorded at 2:55 AM of the intervening night of 21st of August 2022. But according to the investigating, according to the deposition of the investigating officer, he said that the appellant was arrested from his own home at 9:30 AM. 9:30 AM, whereas the according and not only this, the hammer was purportedly recovered from his home, whereas the duty officer is claiming that no, he has surrendered with the hammer in the police station itself. There is a long gap between the place of occurrence as well as the place of arrest and also the place of recovery of the hammer itself. So this is the material defect whereby the prosecution case has completely failed.
Let us hear.
That the blood
We cannot
stain-
hear the appeal. We are not hearing the appeal. The major things you point out. Bloodstain,
blood stain has not been
hammer was not sent, you said.
hammer was not sent.
Head of the hammer was not sent.
No, nothing.
Never produced.
No, never produced.
Only the handle of that.
Only hand
And that too did not contain any fingerprint.
fingerprint.
Let us hear them. Yes.
Well, in this case, this petitioner appellant, he is a carpenter. So regarding the hit with the hammer, he is an expert in hammering. The thing is that, first of all, second, my lord, all the witnesses, PW 1, 3, PW 2 is the complainant, his father, 3, 4, 5, 6, they have stated there was a previous torture upon the this.
But 498 he was acquitted.
Torture in the sense she was hit with a iron stick and her hand was broken. Number one. Second, he was pushed to the river Talma. So there are chains of circumstances.
But that would have come under 498, but he was acquitted of 498. Clear case.
400, 498.
He was acquitted of 498. Then both should have been, he should have been convicted.
That's the chain, my lord.
No, that chain, if you want to
as
rely
there
on
is
that,
direct evidence,
if you want to rely on that chain, then that chain had to be believed by the court. If that was believed, it was an obvious case of 498A, not 302. Previous conduct cannot provide a basis for 302.
That's
What
true.
happened on that day?
That's
Previous
true.
conduct, he
But-
might have been very bad, hit her, but 498 he was acquitted.
That's true.
And
but
302 on that date, child is not
I
examined.
felt when I was going through the judgment.
Yes,
trust-
and child was not examined. 8-year-old child, we
Yeah,
understand.
8-year was not examined. So.
Then 8-year-old is,
8-year child, my lord, because the thing, my lord, his mother expired, my lord.
is when did the police become so sensitive?
And he is
Mother
also-
expert, that's why 8-year-old was not producing evidence. Would have been taken evidence in a child-friendly manner. So that those provisions are there in statute.
That is there, my lord, but yeah, even then, my lord.
Doubt is cast, although it's
There
subject
is no
matter of
doubt,
fact.
my lord, because. my lord,
And
the
more
thing
so
is that-
498A, he was acquitted, that also, because that vitiates the chain of events. That is a difficulty.
Because all the witnesses stated previously there was torture,
Nobody saw anything. May
No.
not have seen, only one person saw.
There are many witnesses who are the
One-
neighbors.
Neighbors saw previous altercation
my lord.
and hitting also,
Hitting
and
also,
torture also.
There is a story of that she was pushed to the river Talma and she was rescued by the neighbors, the villagers. So these things are now at this stage, my lord.
498 he was acquitted.
498, my lord.
Previous conduct cannot
My
be
lord, I
looked
think the
into.
judge, it was in the mind of the jurisdictional judge that, okay, fine, I am giving a 300 to life imprisonment. On one side, he was not found guilty in.
You remember the previous commentary by Ajoy, the cricket matches? What the batsmen are talking between themselves in the pitch? You're doing that. What was in the mind of the judge should be the judgment. Judges speak
But,
through
my
their
lord,
judgments.
but the chain of circumstances has been established, my lord. The entire chain without any break, my lord, without any crack, my lord.
We'll give our reasons. The present application for bail has been filed by the appellant who was convicted of murder under section 302 of the IPC. Although charges were clamped under section 498 capital A of the code, the appellant was acquitted of the said charges but was convicted only on section 302. Next para, learned counsel for the appellant submits that although admittedly the only person present at the place of occurrence was the 8-year-old child of the appellant and the victim within bracket his wife bracket closed, the said child was never brought for adducing evidence as a witness, for which adverse inference ought to be drawn against the prosecution. Secondly, it is submitted that none of the witnesses were eyewitnesses and they adduced evidence on the basis of hearsay. Next para, more importantly, it is pointed out that although the duty officer adduced evidence to the effect that the appellant was appellant surrendered in the police station with the offending weapon, a hammer at around 2:30 a.m. in the wee hours of the morning, the journal diary was lodged on at 8:30 a.m. The investigating officer, in contradiction with the version of the duty officer, stated that the appellant was nabbed nabbed from his home with the offending weapon. Apart from such contradiction, it is pointed out that the offending hammer head was never produced, but the handle thereof, which was a wooden bar, was produced as exhibit. However, there was no fingerprint on the said handle. The prosecution, it is alleged, also relied on extrajudicial confession of the appellant. Next para, learned counsel appearing for the state submits that the appellant is a carpenter by profession and as such, the case made out against him as to the murder being committed by hammer is most credible. Next para, as regards the non-production of the child as witness, it is insinuated by learned counsel for the state that due to the tender age of the said witness, he might not have been produced. That apart, the chain of events has been established, since it is submitted, almost all the witnesses corroborated that there were previous instances of physical assault on the victim by the appellant husband. On one occasion, it is alleged that the victim was pushed into a water body and subsequently rescued by the other neighbors. Next para, surprisingly, we find that the antecedents as sought to be brought out by the prosecution before us would have made out a foolproof case, if proved, of an offense under section 498 capital A of the IPC, however, in view of the appellant having been acquitted on such count, the credibility of such evidence is somewhat doubtful, at least at a prima facie stage. Next para, moreover, the antecedents of a person or past quarrel or conduct cannot be a direct evidence on such a serious offense as murder. Next para, that apart, we find that a strong arguable case has been made out in the appeal inasmuch as the sole probable eyewitness, that is the 8-year-old child of the parties, was not adduced in evidence. Next para, in such view of the matter, we find that a strongly arguable case has been made out in the appeal. Moreover, the appellant is already in custody for about 5 years, and since the trial is over, there is less chance of the trial being affected by the appellant being enlarged on bail. Full stop. Accordingly, CRA CRAN 2 of 2025 is allowed. They were granting bail to the appellant on condition that the appellant furnishes a bond of rupees 10,000 with two sureties of like amount each, one of whom must be local. Full stop. The appellant shall not leave the territorial jurisdiction of his residential police station throughout the pendency of the appeal, and shall make himself available as and when called for by the appellate by this court. Full stop. Next para. That apart, comma, the appellant shall report to the local police station. What is the local police station?
Kotwali police station.
Kotwali, that is a Kotwali police station, once every month. To the local police station na bole, to the officer in charge, stroke inspector in charge of the local police station, that is the Kotwali police station, once every month, and shall not in any manner try to intimidate or approach the witnesses in the trial and not tamper the evidence in any manner whatsoever. That's this.
My lord, one indulgence, my lord.
Yes.
On the last occasion, that was on 21st. This bench was there, my lord. In the order sheet, my name will be there instead of Aditi Shankar Chakravarti. It has been missed. I'll just make a correction.
Ensure that proper slip is given.
I'll just.
So only one correction was GDNT was recorded on
এটা তো আছে না?
25.55 hour. It has been gone into an 8:30.
What was the time?
2:55
আচ্ছা 8:30 যেটা করেছি 2:55 ওটা GD entry 8:30 একটা জায়গাতেই আছে ওটা 2:55.
What are this correction may be in CRAN number 1, my lord.
In the previous one?
Previous one.
But in this matter? So long back?
No, 21st, my lord. My lord was there. This bench.
No, this circuit?
My lord, this
আচ্ছা আচ্ছা. Order dated 21st of
July.
এটা একটা সেপারেট লেটার বলে করে দেবেন। In the order dated July 21, 2025, comma, the name of the counsel appearing for the state was erroneously recorded as Aditi Shankar Chakravarti.
Instead of Niloy Chakravarti.
Yes, I know it. Instead of Mr. Niloy Chakravarti, Fusap, let it be deemed that the said correction is effected in the order dated July 21, 2025.
Great.
Milord, this is Milord an appeal arising out of the POCSO Act. Milord, 20 years imprisonment and 7 years custody, Milord, but one thing, the victim is not yet served. So Milord, a direction may kindly be given on the state. But tomorrow, if can be taken up.
Tomorrow will be very difficult for them. Monday will keep it. Since the victim has not yet, de facto complainant was a victim.
No, no.
De facto complainant has to be served or victim?
Yes, de facto complaint.
Since the de facto complainant has not been served as yet, comma, the appellant as well as the state are directed to ensure that a notice of the appeal is served on the de facto complainant, indicating the returnable date, full stop, the application. Whatever mode, we have not specified the mode, you choose your mode. We have kept it fluid, delivered. The application shall next be listed on July 29, 2025. We are putting it on Tuesday to give them some time.
Lord, great.
Thank you.
Tuesday, my lord.
Tuesday.
Item number 12.
That was date fixed.
12, another date is fixed.
Yes, I am for Dhiram
What is the date fixed?
28. I am for the respondent petitioner.
No, we have fixed it on 28th. ভুল করে এসে গেছে নাকি? Order নেই সেটা। না কিছুই তো নেই অর্ডারে। দিন কিছু করতে হবে না, ভুল বলছে তো। Apologies accepted. Mr. Subhashish Mishra. No. Maybe mistake on the part of anybody. Yes, what is that?
It's an admission stage criminal appeal.
Oh,
CRAN application. The CRAN application is for condonation of delay, Lordship.
What is the delay?
47 days delay.
47. Who is for the state? Mr. Chakravarti is there. Mr. Nila Chakravarti.
Yes.
Appear for the state. Will regularize your. The appointment of Mr. Nila Chakravarti. What is your designation? We forget.
I'm APP here.
The appointment.
APP, I am only for
The appointment of Mr. Nilay Chakraborty, APP, along with a junior of his choice, is be regularized. Full stop. Since sufficient reason for the delay in preferring the appeal has been made out, CRAN 1 of 2025 is allowed, thereby condoning the delay in preferring CRA within bracket DB 36 of 2025. Full stop. The appeal is admitted and will be heard on the grounds taken in the memorandum of appeal. Issue usual notices. Call for the records. Liberty to the appellant. It's a victim's appeal. No liberty, no question of interest. Yes.
Number 13.
This is first appeal,
Yes.
my lord, when I filed the paper I served.
Parted first appeal. Was it parted by us?
It was hard, because what happened now, I don't know why it is parted.
Parted আমি বলেছিলাম আমরা।
I appeared on the last occasion, nobody appeared on behalf.
Give us half a second. What will you? Us. We will not keep it as parted if, because otherwise if you can't conclude it, it will be difficult for you again to.
Parted. That is, I said what happened, man, the last time.
আচ্ছা তাহলে ঠিক আছে পরের দিন থেকে পাঠাতে দেবেন না।
The matter was appeared on the last application.
Yes.
Nobody, I served the copy of the paper book to the Division 1, my lord, who is the co-sharer.
Yes.
But he did not turn up. Then again given a notice to the, he did not turn up. I filed a service. Now last time,
You are fair enough and you said that another notice should be served.
okay, but the lawyer did not accept it. He said, no, once I've accepted, I intimated them, so he has not.
They directly serve on them. Who has not been served?
No, I saw Division 1 is appearing, he's the co-sharer. Other the subsequent purchaser of the.
So notice of the appeal has been served on them.
His paper book was served.
So what is the notice of the appearance of the matter in the list?
Yes, well, that was also once I served, that did not turn up. Then he also kindly.
Learned senior counsel appearing for the appellant submits that despite an attempt to serve on the learned advocate representing the respondents in the trial court, the said learned advocate refused to accept the same, since he does not have any contact with his clients at present. Full stop. Next para. However, we find from the records. What is the appeal about?
The appeal about the partition shoot.
We find from the records that service of the notice of appeal has already been effected on the respondents and the paper books have also been served. So accordingly, there cannot be any impediment in taking up the appeal. We'll direct it to appear under the usual heading on Monday. Because if you take up appeal hearing, you can't reach the death reference and the other one.
Short matter.
What is the point?
The partition was dismissed on the ground of that non-joiner party was the least pendency. Others said that the title could not be, we were not able to prove the title. There is no dispute between the plaintiff and the defendant regarding the property. They have not said, I am not sure.
No, but once somebody purchases,
No,
yes,
they are not disputing. They are not.
they have to be impleted.
They have been impleted. No. Yeah, what happened? Sorry.
Have to be impleted. They are now.
No,
also
this is not
co-owners.
the question. Question is that minor, Division 1 is a co-sharer.
Right.
He, during cross-examination, he said, the chief said, well, I transferred a part of property to my wife.
So wife is a necessary party then.
But he did not come forward during the chief.
He produced any transfer deed.
No, he produced the deed. He
Then-
said that the shoot of 2018, 2021, he transferred to a part of to his wife. And the 2023, when he, during his chief, he said, I transfer part of to my wife.
Lispendence operates as I mean that it will be the whatever happens in the decree will be she will be bound.
Yes. So, my lord, on this ground,
But partition should the present
that,
should be.
my lord, your lordship, judgment, this is Sanjeev Bhai's judgment, my lord, yes. He's transferred before the filing of the suit, my lord.
So
Then
that's
is-
his manager's judgment we have, cite it. I hope I had not said, I was not sitting with him. Yes, I was sitting with him. Yes.
I'm not saying.
What was held there?
He was.
anyway.
Forensics.
It's a coordinate judgment all the same.
But the judgment was. I'm not saying. Paragraph 5 and 6. Yeah, that has been clarified. This is his duty.
Just let us check. From the judgment, language tower. একবার ট্রান্সফার প্রপার্টি একটা আছে একটু দিন তো।
I'll give one.
You have a copy? আপনি দেখুন তো ওদিকে সেকশন 52টা একবার দেখতে হবে। ফোনও নেই আমার কাছে। Can you, Mr. Rai, ask you learned junior to find it from his phone by a Google search and just read it out to us once?
Section 52.
Obviously. Just so that, just read out, we'll just. পাওয়া গেছে transfer. Yes, you've got a copy. Leave it, we have got it. There was no application for implement filed by them here.
No, fine. On in chief, he has said that a part of the what I transfer to my wife. Not the entire, a part of. I'll show it, madam.
No, but how can a complete decree be passed? That is what we are thinking. In a partition suit,
But decree is this pendency
That's-
binding on him.
so her purchases share should get a right in that.
Yes, but
Whatever share is allocated to her
Yes, sir.
vendor, sorry,
Pendants.
vendor, that
He's a wife, he gifted to his wife.
if he gifted, if
So,
the without the wife, the vendor's share could be declared and she will.
he admitted my lord, second defendant one, admitted the entire my case. In the cause he entered my case.
Yes, let us see the judgment, impugned judgment here, in your case.
Yes. If the last can come through.
That was the only ground, non-joinder.
This one.
What is that?
It said that the plaintiff could not able to prove the title. There's no dispute with the title regarding property.
No, but it can be a collusive suit. You have to prove something
No.
regarding title. You have
The
the plaintiff.
defendant one admitted what happened, my lord. I showed that.
Deed of sale,
No, this is from the record of rights. Record by John,
exhibit 3 and 4 are sale deeds. What are these?
these are the subsequent purchases.
Subsequent
Uh,
purchase by?
By the, division 2 to 4, the subsequent purchase of the undivided share of the property.
Interstate.
Interest. But you also can see what happened, we got this property, say from the
So you
arrest record of right.
produce the arrest records of rights?
Arrest record of right.
LR records of rights, actually.
And-
Certified copy of LR records, exhibit 1.
Yes, can you-
You have produced the entire records of rights,
yes. And the arrest record, this is jot down, alone.
and that is admitted by the defendant, the title.
Yes. Completely admitted.
Show us, Mr. Rai, the admission.
Yes, you can come to page 31, cross-examination DW1, entirely admitted. Page 31 of the. What in my case, he admitted everything. He also said the share, he said that he's recognized some land excess.
Oh, entered thing.
He,
It's a collusive suit, we can understand,
Right.
but
No,
that,
come on.
that was rejected. Unfortunately, that was dismissed. Let us come to the impugned judgment once, Mr.
sometimes may not be.
No, the
That first, this is my.
the decision.
This is my thought. I said to my advocate, so also can I come to the, it started page 34.
Let's come to the decision with reasons.
My lord, the relevant is page 34. First point, it uses page 44.
Acha.
Page para 16, 17.
No, where the gift deed was produced by him.
Yes, sir.
But you have annexed only your, in the paper book, you have incorporated only your exhibits.
No. They're not explaining.
So you are saying that they produced the gift deed? They did not exhibit the gift
They
deed?
said, no, they're not exhibit, they said on.
Then the court in any event cannot look into that.
But this is 16, 17. Can you say when he has produced it? When he said it, there is chief.
According to him, the gift deed was executed when?
In 2021,
A suit was filed on 2018.
18. And he had deposited in 2023. In cost, he said much more. This is a first one at page 46. This is a paragraph 19 at last part. The necessary parties should have not been included, but absent question of partition cannot be actually the issue does decide for the defendant. Here, manager recorded it. 18 the should have 18 to the 21 the transfer to the 23. He disclosed it first in the chief. And second one starts from page 47.
Yes, we are passing judgment. The present first appeal, despite service of notice, none appears. যা বলেছি এর আগে তারপর থেকে add হবে. Despite service of notice, none appears for the respondents at the time of hearing. Push up next para, heard learned senior counsel for the appellant, plaintiff stroke appellants. Push up next para, the partition suit of the plaintiffs stroke appellants was dismissed by the learned trial judge by dint of the impugned order, impugned judgment and decree, primarily on two grounds, that the suit was bad for non-joinder of the wife of one of the defendants, in whose favor a gift deed was executed by the said defendant, and secondly, that the plaintiffs had failed to prove their title to the property. Which of next para, learned senior counsel cites a coordinate bench judgment of this court sitting in the principal bench, in the matter of such and such versus such and such reported at AIR 2018 Cal 102, where the division bench, by placing reliance on the doctrine of lis pendens, held that in the event a transferee pendentility does not apply for impleading himself stroke herself as a party to the suit, the suit cannot be declared, cannot be held bad for non-joinder of such party. Push up next para. Senior counsel also places reliance on the several exhibits and oral evidence adduced on behalf of the plaintiffs. For the next para, we find from the evidence on record that elaborate documents were produced to show the recording of the names of the plaintiffs and the defendants in the concerned records of rights, coupled with subsequent sale deeds, transfer deeds executed inter se between the parties, where their title was also asserted. Full stop. Such documents, coupled with the corroboration by oral evidence led by the plaintiffs, was sufficient for the purpose of arriving at the conclusion that the plaintiffs have proved their title to the property. Full stop. Next para. It may very well be that title deeds of an antecedent period may not be available. However, the test applied in a civil case is preponderance of probability. By applying such legal yardstick in the present case, we find that the plaint case was amply proved by virtue of oral and documented evidence. Next para, also, the defendant's witness, in his evidence, categorically admitted the plaint case. Since the judgment and decree in a partition suit is in the nature of a judgment in personam, the admission of the DW1 in respect of the title and the shares of the parties is binding on the defendants, and as such, the learned trial judge ought to have passed a preliminary decree of partition on the basis of the admitted shares of the parties by declaring their respective shares, which would be binding only between the parties. For next para, on the second count, the ratio laid down in Rajul Mukim Supra is binding on us, full stop. Even on a plain reading of section 52 of the Transfer Property Act 1882, which categorically recognizes the doctrine of lis pendens, a transfer during pendency of the suit is barred. Full stop. The legal effect of section 52 has been interpreted by courts in several judgments, both of the apex court and different high courts of the country, to the effect that although such provision does not absolutely bar such a transfer, the transferee pendentility is bound by any decision which is arrived at by the court in the proceeding, in the legal action during which the transfer was effected. Next para, although the Supreme Court, in certain judgments have held that in the event a lis pendens transferee seeks to implead herself or himself as a party to the suit, such application ought to be allowed, since section 52 of the Transfer Property Act, per se, does not prevent such a party to be impleaded in the suit, at the same time, it has also been the consistent legal opinion that merely due to non-joinder of a transferee pendentility, a suit cannot be dismissed for non-joinder of such party. Next para, the principle underlying the same is that the genesis of the title of the transferee pendentility is in contravention of the doctrine of lis pendens as embodied in section 52 of the Transfer Property Act 1882. As such, a transferee pendentility, in any event, shall be bound by the decision arrived at by the court in the suit, even without impleading such transferee. Hence, the learned trial judge erred in law in holding that the suit is bad for non-joinder of the transferee pendentility. Another important facet of the matter was overlooked by the learned trial judge while passing the impugned judgment. Although claiming that a portion of the property was gifted in favor of his wife, the concerned defendant did not exhibit any document of transfer at all. Thus, even the case of transfer pendentility was not established by the defendants during the pendency of the suit. As such, the learned trial judge erred in law and in fact on both counts. Hence, FAT 30 of 2024 is allowed ex parte. thereby setting aside the judgment and decree dated May 18, 2024, passed by the learned civil judge, senior division, Sodor at Kuch Bihar, district Kuch Bihar, in title suit number 37 of 2018, and remanding the matter to the learned trial judge for a fresh adjudication of the partition suit on merits. First up, in view of the long pendency of the matter, comma, it is expected that the learned trial judge shall expedite the hearing of the suit and, comma, preferably dispose of the same within 1 year from the date of communication of this judgment to the said learned trial judge. A formal decree be drawn up accordingly. Interim order, if any, stands vacated. No order is to cost. এটা জাজমেন্ট ফরম্যাটে হবে। আমরা বাউন্ড নই, ওরা যদি না অ্যাডাপ্ট করে আমাদের কোনো সমস্যা। থ্যাংক ইউ।
Lord, I appear for the appellant.
Yes, Mr. Ghosh. Right.
So that two reversals, my lord.
Two reversals?
Two dismissals, I'm sorry. Dismissals.
So affirmance. What is the background?
Suit was for declaration.
Mr. Anamis, you can take your seat and you also can take. Yes.
There is a suit for declaration and injunction. The plaintiff.
No chair behind, both of you. Yes, very well. Mr. Ghosh, please continue. We are disturbing you. You are the plaintiffs.
I was the plaintiff. The suit was for declaration and injunction.
Declaration of title.
Declaration of title and injunction against the defendants on the premise that they are attempting to dispose of me.
Right.
Now, my genesis of title was that I have purchased the suit property. It was gifted to by my predecessor to me, two joint predecessors, two joint subsequent transferees. I along with my brother. Now, I proceeded in the suit alone. My brother proceeded with a different suit on his portion of land, though it was not formally partitioned. Now, the exhibited documents was the sale deed.
You sought your share in the property.
For the entire
Exclusive
land.
How could you?
I preferred the suit on the premise that on the exclusive possession.
So dismiss for non-joiner of your brother.
Non-joiner of my brother. Now, my lord, I am only hanging on one
Thin
question of
thread,
law.
and you are very heavy.
Very thin thread, that in a
Yes.
suit for ouster of third parties, when I am making an attempt, taking a legal recourse to preserve and protect the property, even if it is by one of the co-owners, it should be deemed that he is acting on behalf of all the co-owners. I'm slightly, my lord, relying on a judgment of the Supreme Court on this. And that's the only principle, my lord, ground number 19 of my memo.
It was dismissed only on the ground of non-joiner.
Only on the ground of non-joiner.
Other grounds, she says. Let us.
Yes. Milord, kindly takes the trial court's decree first.
Let us come to the appeal court first,
Yes,
because that will reflect the trial court also.
definitely.
If there is something missing, we can go
Milord,
back.
the last portion, 11. Internal page 11, paragraph 11.
Yes.
It is now apparent from the above discussions that the plaintiff has managed to prove the fact that he was owner and was having possession over half of the four suit lands, that is the suit property, but his suit is otherwise liable to fail on account of inadequacies in his plaint, which makes the passing of the decree in his favor not excusable.
What are the other ways in it?
Is this Milord would find, Milord?
Para 9.
Para 9, yes. The last portion.
No description.
Yes. Has not given any description. Suppose the half shares of each of the four plots of land is laid unidentifiable without having any boundaries shown to be button and bounded to the said plots.
Let us once see the decree so that you can get a
Yes.
picture of the property. এটা কোথায়? Oh, no boundary, nothing.
Boundary was not. Milord, since it was, Milord, an undivided property, Milord.
You have
the boundary
claimed
was not.
the entire property.
I have claimed 2.88, which is the scheduled property.
Cite the judgment.
Yes.
Any other point which you are missing out, Ms. Nanuis?
This
Very well.
2.1 is non-joiner of the part.
Unidentifiable.
bad because it's an unpartitioned property declaration suit, how it can.
No further hearing, only what we want, because at this, that's, you
This
don't have a
much,
right,
this much.
yes. Yes, Mr. Ghosh, which is the relevant paragraph. Section 52 is haunting us today,
No.
because
section
that is one of the
52
provisions here,
section
although,
52 is also dealt with here.
yes,
Let's,
different.
Paragraph 6.
6.
Having heard the learned counsels for the parties, we are satisfied that the appeals are liable to be dismissed. It is well settled that one of the co-owners can file a suit for eviction of a tenant in a property generally owned by the
Mr.
co-owners.
Ghosh, that is the distinction.
That,
Eviction you
but
can.
the principle is probably the similar text, the next line. This principle is based on the doctrine of agency. One co-owner filing a suit for eviction against the tenant does so on his own behalf, in his own right, and as an agent of the other.
Mr. Ghosh will deal with this as well. We'll dismiss, but deal with this. The present appeal has been preferred against a judgment of affirmance whereby both the courts below dismiss the suit of the plaintiff stroke appellants, comma, for declaration of title and permanent injunction, comma, primarily on 2 grounds. First, comma, the courts below held, both the courts held that the suit was bad for non-joinder of the other co-owner, comma, being the brother of the appellants, and secondly, that the suit property, comma, as per the description in the plaint, comma, was unidentifiable. Full stop, next para, learned counsel appearing for the appellant cites such and such namta diye deben, reported at 2004 3 SCC 178 for the proposition that it is well settled that one of the co-owners can file a suit for eviction of a tenant in the property generally owned by the co-owners. Full stop. It was further held that this principle is based on the doctrine of agency, and one co-owner filing a suit for eviction against the tenant does so on his own behalf, in his own right, and as an agent of the other co-owners. Full stop. The consent of the other co-owners is assumed as taken unless it is shown that the other co-owners were not agreeable to eject the tenant, and the suit was filed in spite of their agreement. Full stop. Learned counsel argues that in a suit to protect the property, comma, even one of the co-owners may maintain the suit if it is, unless it is proved that the other co-owners resist such attempt. Push up next para. As regards the description of the property, comma, learned counsel submits that learned counsel submits that the property was sufficiently described in the schedule of the plaint. Push up next para. From a bare perusal of the schedule of the plaint, comma, we find that the same does not give any boundaries to the property, and the nature of the property and its exact measurements and location cannot be identified from the schedule. Push up. Thus, comma, both the courts below were justified in coming to the concurrent finding in that regard. Next para. The second proposition sought to be argued by the appellants, comma, although interesting, comma, is specious. Full stop. Next para. What holds the doctrine of agency holds good in a suit for eviction against one of the in a suit for eviction against the tenants stroke licensees stroke trespassers, comma, because of the simple reason that in defense, comma, a tenant stroke licensee stroke trespasser cannot dispute the title of the plaintiff. Moreover, comma, the scope of an eviction suit is confined to whether the appellant, whether the plaintiff has a better title than the defendant, and or otherwise comes within the purview of the concerned Rent Control Act, comma, if applicable. Full stop. No question of title is required to be decided directly and substantially in a suit for eviction. Full stop. In contrast therewith, comma, in a suit specifically filed for declaration of exclusive title of the plaintiffs in a property, comma, it is the title which is the paramount question and has to be decided by the court. Full stop. In such suits, comma, as in the present case, comma, if the plaintiffs, comma, being only co-owners in respect of the property, comma, seek a declaration of exclusive ownership, comma, the suit is bad ex facie on such count alone. Full stop. Next para. Secondly, comma, in such a suit, comma, whatever decree is passed, comma, would directly and substantially affect the other co-owners of the property. Full stop. As such, comma, the other co-owners come within the definition of double inverted comma, the proper parties in such a suit. Full stop, next para, in such view of the matter, comma, we find that that both the courts below were justified in coming to the concurrent findings on the above issues. Full stop, there is no substantial question of law involved in the appeal. Full stop, accordingly, SAT 8 of 2024 is dismissed under order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2024 is consequentially disposed of as well, no others to cost.
I give my name.
You give your name, record your name definitely, but cannot record your arguments. We'll come back in 10 minutes for that.
But I was not that ready, my lord, and
We understood.
abruptly
We
I
understood.
started.
We understood.
But one thing I missed out, my lord, which I would like to, my lord, take your lordship first, my lord, the dying declaration of Momita, which was recorded just 2 days after, my lord, she was admitted in the hospital. My lord,
Just remind us, this is 302, right?
no, my lord, sorry.
Just remind us.
This is 396, 397, and 398. Dacoity and murder.
Yes, right.
Yes. Lord, that's page number 1 of part 2. Lordship will find it after page 156.
Yes,
Lord, dying declaration.
dying declaration.
Yes. Part 2, page 1. Lord, this was recorded on 1st of August 2023 in the hospital, Evlad Nursing Home, Jalpaiguri.
Page 1.
Page 1 of part 2, my lord. After,
Yes, dying declaration.
yes. It starts recorded on 1st.
Oh, yes, sorry, right. Sorry. By mistake.
But the incident occurred on 28th July at 2:30 a.m. in the morning.
Yes.
And 1st of August, this was recorded. My lord, it starts from how, my lord, the last paragraph.
Yes.
I was sleeping in separate room next to the bedroom of my husband. All of a sudden, my sleep was disturbed. I can see 6 people entered to my room. 4 were male, 2 were female. 2 male attacked me all of a sudden around neck area with sharp object. I suddenly gave strong bite to his illegible and she fell down, facing my face down and backside up.
For dying declaration, she also died subsequently.
No, she did not, but it was recorded, my lord, as per the instruction of the police.
Dying declaration?
Normally, my lord, when there is a chances that the patient may succumb to injuries, my lord, dying declaration is recorded. But in this case, police instructed the doctor and doctor has recorded it. This was the first statement, my lord, made by her.
All right.
Yes, appellant.
Lord,
Yeah. Poor person is living and we are taking a dying declaration.
no, my lord.
Yes, understood.
Yes.
Understood.
So, my lord, here she says that I gave a bite, she fell down. She says
Can be so dramatic about the bite.
Lord may ignore that, but she says 6 people enter.
Yes.
And she gave a bite, she fell down. Now, my lord, next page.
Hmm.
They stabbed me several times on my back,
Hmm.
both arm side of illegible area. I made myself dead person, then attacker left me alone. I went to save after crossing the boundary wall of my house. I hide there. In the morning, I hear vehicle sound running nearby. I call them several times for help. So I got help who helped me to bring me to Dhupguri Government Hospital for treatment. Person who brought her to Dhupguri Hospital, Mrs. Fatima Khala, Neeraj Roy, Deba Hossain, they are all my neighbors. My lord, kindly mark this line. These people, these persons who brought her to the hospital. This was the very first statement, my lord, she made. And next line, my lord, she says, she takes the name of Aftab. Do you know the...
This was that Ashok Roy case. Ashok Roy was one of the neighbors. Or we are
That was-
confusing with
that
somebody.
was subsequently, my lord. That is why
Yes.
First
Right.
statement, they are-
So the next statement was that those people on the van or whatever
Yes,
vehicle
yes, yes.
took her to Ashok Roy, who
Yes.
took very well.
So
Let us.
these are, my lord, improvements, my lord. This was the first statement.
Hmm.
These people named these people, but subsequently, lordship will find these people were nowhere in the record. No witness, nothing, my lord, nowhere. Then says, do you know the person who attacked you with sharp object? She says, yes, I know the person, MD Aftab, relative. Second person, I don't recognize. So, my lord, this was the first statement she made. Now, my lord, kindly come to the 164 statement of Momita. That was the second statement made in regard to this incident.
Where is
Page
that?
number 12, my lord. Page number 12 of the first part.
Oh,
First
sorry.
part.
Yes. Yes.
So, my lord, this was recorded on 28th of August, almost 1 month after the incident.
No, both on the same day, dying declaration.
No,
this?
dying declaration of 1st of August.
Oh, yes. Right.
Now, my lord, it starts from this question, say what you want to disclose. She says, at the night of 27th July 2023, after having dinner, I was sleeping in my room at my father-in-law's house, alone, due to my fever. My husband was sleeping in another room along with 2 kids. At about 1 to 1:30 a.m., I was sleeping, keeping the light switched on. I felt that somebody was standing in front or in backside of me. So after opening my eyes, I saw 2 persons were standing beside the almirah placed behind me. One of those 2 was my nephew Aftab Alam, and I saw the other one who was with him for the first time. I did not know him, nor did I know his name. I, having shouted, descended from the bed. To resist me from shouting, one of them pointed a dagger on my throat from behind. There is also the mark on my throat, the mark is visible. One of their fingers had appeared before my mouth, which I bit forcibly. The person whom I had bitten also bit on my left shoulder. So here also, my lord, she does not name specifically Aftab with respect to the mark in the finger. My lord, in the dying declaration also not, in the 164 statement also not. But lordship has gone through the evidence where she has specifically names Aftab Alam, that Aftab tried to put the finger and she had bited the fingers of the Aftab. So, my lord, these are
She had bitten Aftab. That is not stated here in these two.
no. So, my lord, slowly lordship will find in all the subsequent
Embellishment.
Yes, embellishments and improvements. Yes. Thereafter, but thereafter they fell me down. Hearing my shouting, my husband also woke up. He shouted from there, but seemed that someone was near him too, who resisted him and continued assaulting him. Thereafter, they continuously chopped on my back with dagger. There are marks of injuries caused by dagger throughout my back. I sustained injury in my kidney also. I had to remain admitted at Anandalok for several days. Now, Lord, the more I was restless, the more they chopped me with dagger. As I had pretended to be dead, they released me. Then they, having left me, went to the room of my husband and kids, situated beside that of mine. As and when they had entered that room, I heard that some more persons, probably for the reason that they were unable to tackle my husband, were saying, "Catch hold of him, catch hold of him." They were conversing in Hindi only. I, having gone there, after somehow managing to lift myself up, found that beside Aftab and his friends, there were 2 more men and 2 women in that room. Now, my lord, this line here, she says that she lifts herself, she goes to up to the room of her husband, but this part is not there in the evidence. She says that she jumped out from the window. There were daggers in everyone's hand, and all of them severely wounded the whole body of my husband by chopping him. The veins of hands and legs were cut, and those were bleeding profusely. They had already threatened the kids not to shout, both of them also standing on the threshold of the door after having descended from bed, witnessed the whole occurrence, how they collectively, 6 persons, murdered their father. I, having presumed that I would not be able to deal with them, returned to my room without calling anyone, thinking that I would rather jump through the window and bring somebody else after calling him. While jumping, my hands and legs got scratched. As my back had been chopped with dagger, it was bleeding profusely. The floor was filled with blood. Having descended after jumping somehow, I realized I had exhausted. I hid myself behind a guard wall situated at a vacant place beside there, with a hope that if I could find somebody else, then I would stop him by signaling with my hand and seek his help. I stayed lying there. Later on, I heard from my kids that after killing my husband, they came to my room for searching me out. They conversed among themselves by saying, "Where she has fled, where she has fled." At that opportunity, the kids went to the adjacent house for hiding themselves. I too heard that they were searching for me. Thereafter, I saw that some people were bringing welding machine on a small truck. I knew them. They were approximately 10 to 12 persons. I had signaled with my hand and they came. I requested them to save my husband and kids. They took me at first to the adjacent house. At that time, they did not say anything. Later on, after returning from the nursing home, I came to know that when they saw that my husband had already expired, my kids were not present at the place of occurrence. They were hiding in the adjacent house. The name of the man was Potan. Afterwards, my kids said that before dying, the husband requested, well, these are the normal things. Now, the question is, but she says that she was taken to the house, adjacent house. She does not specifically name anyone's house. Milord, may kindly see the sketch map once of the place of occurrence, page number 10. Milord will find the PO, page 10. Yes.
PO form.
PO, yes. Milord, beside PO, there is the kitchen.
Hmm.
Milord, left side is the bedroom of Momita. On the same building, Milord. Left Q is the building of bedroom of Momita. The middle room is the PO where her husband was sleeping, and Milord, the right room is the kitchen. These are the three rooms in the house.
The legend is not there, the alphabet, next,
Yes,
next
yes.
page.
Next page. my lord.
Very well, yes.
Yes. My lord, B, number B is the house of Ashwini Roy. My lord, this is very important because the kids say that they went to the house of Ashwini Roy.
Ashwini or Ashok?
No, Ashok was the, Momita went to the house of Ashok.
Acha, Ashwini Roy, the children went.
Children went.
Very
but-
well.
But my lord, in entire sketch map, lordship will not find that there is any house which belongs to Ashok nearby, adjacent. Let me see the sketch map. C, just above BC. This is the house of Mohit Alam, one of the relative.
Hmm.
Milord will find thereafter D. D is a vacant land of Amit Roy. Just after D is E, that is a grocery shop. Milord, G is the garage of the deceased person, the Mehta Walam. H, again H is the house of Mumtaz Ansari. Milord, these are the adjacent house, milord, as per the sketch map. Milord, just behind the house of the this accused, the deceased person, there is a vacant land.
Which is the rare portion? The A is the rare.
A is the vacant land. So, milord, these all 3-4 houses, adjacent houses are there, but lordship will not find the house of Ashok Roy there. And milord, most interestingly, milord, this house of Ashwini Roy, the children went there, and he was a vital witness. But milord, from the records, I find that Ashwini Roy was never summoned before the court, nor he was examined as a witness. And milord, just after the road, milord will find a school.
Yes, Bangshibodhan.
Bangshibodhan High School.
Yes.
So it is 30 meters from the place of occurrence. So this is the distance milord may ascertain from the place of occurrence till the school, which is after crossing the main road. The distance is 30 meters.
All right.
Now, milord, on this background, milord, let's continue with the evidence. Milord, will continue with PW3. Milord, the elder son of Momita.
This is page?
Page 58, milord.
Yes.
But almost similar to what his younger brother deposed, milord. Page 59 is the relevant portion. It starts, milord, examination in chief. My father was, Mehta Walam was my father. He was killed by Aftab Dada and his 5 friends. Out of them, 2 were females. Aftab Dada is present in court today, identified. On 27 July 2023, at about 10 p.m., myself, my brother Ayan Alam, and my mother Momita Dash, my father were in our house. Myself, my brother, and my father were sleeping in a room, and my mother was sleeping in another room due to her illness. At about 1 to 1:30 at night, we woke up after hearing screaming of my mother. When my father was trying to enter into the room of my mother, 4 persons came out from the kitchen and started assaulting my father with a knife. At that time, light of the room was on, so I identified those persons. My father sustained bleeding injury. Thereafter, Aftab Dada and his another friend came out of the room of my mother and started assaulting my father with a knife. When myself and my brother were trying to come out of the room, accused persons told us, "Agar tum log chillaoge, tumko bhi tumhari papa ki tarah mar denge." My father told them, "Mera 2 bachcha hai, mujhe chhod do aur jo kuch lena hai le jao." The accused persons also told that, "Bhag gayi," and started searching my mother. When they were searching for my mother, my brother Ayan hurriedly fled away from the room and took shelter in the house of my Jethu, Ashwini Roy. When I came to my father, I found that he was lying on the floor with bleeding injury. Thereafter, I fled away and took shelter in the house of Ashwini Roy. I told Ashwini about the entire incident and he informed the local police. But milord, this Ashwini is not the de facto complainant. After half an hour, police came to our house. In the meantime, the accused person also started searching for us. We stayed in the house of Ashwini Roy in that night. Myself, my brother, and my Jethu went to jail at Jalpaiguri for identification of the accused persons. I identified all 6 accused persons in jail. I gave my statement before the landed magistrate in court and I put my signature on the statement in English. This is my signature. Let the statement be marked Exhibit 4 and signature be Exhibit so and so. The accused persons also assaulted my mother with knife. My mother told me that Aftab Dada and his friend assaulted her with knife. Now, my lord, the cross-examination. When my brother fled away from the room, I also fled away after 1-2 minutes. House of Ashwini Roy is adjacent to our house. I knocked the door of Ashwini Roy. When I reached there, Ashwini and his family members came out of the room. There is one road from my house to reach the main road. There is another road on the back of our house to reach the main road. There was a house on the back of our house, but no one resided there. The house of Ashwini Roy is visible from our house. The house of Ashwini is on the right side of our house. There is a road on the left side as well as on the front of our house. There is another house on the left side of the house after the road. Ashwini Roy and his family members came out immediately after knocking the door. I told them about the incident, but none of them came to my house. When I took shelter in the house of Ashwini Roy and narrated the incident, at that time local people was not there. I cannot say how the accused person left the spot as I was not present at that time and took shelter in the house of Ashwini Roy. After the incident, I did not return back to my house. On the next day of the incident, I went to the house of my Dida. My mother came to the house of my Dida after discharge from hospital. After the incident, I never went to the local PS. The report of the incident was telecasted in news channel. And thereafter, my lord, not a fact and general denial. So, my lord, he also says, my lord, that report was incident, the incident was reported in the news channel and everything was known. My lord, the accused persons were also, my lord, disclosed, the details were also disclosed, and finally, thereafter, the TIP was done. My lord, next, PW4, my lord, the de facto complainant. Ranendranath Chakraborty.
Yes.
But he says, I am the complainant of the instant case. Mehtab Alam was my neighbor. He is not alive. He was murdered by his own nephew, Aftab Ansari. On 28 July 2023 at 15 hours, that is on the night of 27/7/2023, I received a phone call on my mobile phone by a person who asked me to come immediately at Angra Bhasha, where an incident of murder took place. That person also told me that Mehtab Alam was murdered. I immediately rushed to the spot and found huge number of people gathered there. I found that wife of Mehtab received multiple bleeding injuries all over her body and she was taken to the hospital by an ambulance-like vehicle. But kindly note ambulance-like vehicle. Thereafter, I entered into the room of Mehtab and found floor of the room is covered by blood and Mehtab was lying dead on the floor. I heard from the local people that sons of Mehtab took shelter in the house of Ashwini. I also heard from the local people that a group of 6 members consisting of 3 male and 2 female, including the nephew of Mehtab Alam, entered into the house of Mehtab from the backside window for committing dacoity. And they killed Mehtab and also injured his wife. Not first time this is coming from the backside window. Sons of Mehtab somehow managed to fled away from the spot.
This is entirely hearsay, basically.
Yes, yes.
He admits. I mean, got the news, came and heard.
Yes.
So therefore, there may be discrepancy in hearsay evidence. We won't go by that. I mean, not even in your favor. I mean, but there may be some discrepancies. But his evidence goes as a witness on the ground of hearsay.
Yes.
Complainant at best came there and lodged the
Yes, he
complaint.
heard it from the local.
So whatever he says is not so material, apparently.
Just
He
two
lodged
lines
complaint on hearing from others.
Just 2 lines thereafter. I also heard that all 6 accused persons are from Delhi. Next, Milord, very important. Local people chased all 6 accused persons and managed to apprehend them near Devmali and handed them over to police. I saw all of the accused persons. Now, my lord, if they were apprehended at Devmali, which is around 5 to 6 kilometers away, Lordship will find this in the further evidence. My lord, how come he has seen the accused persons there? My lord, very doubtful. Accused Aftab Alam is present in court today, identified. This is my complaint. It was prepared by one Muniruddin as per my dictation, and I put my signature on it after going through its contents. Let the complaint be marked Exhibit 5 and signature be marked as Exhibit 5/1. Now, my lord, the cross-examination. Distance from my house to the house of Mehtab is about
বলছে Yes.
Yes. The distance from my house to the house of Mehtab is about 500 meters. I have a business. Within 9 p.m. I used to go to bed. I did not disclose the mobile phone number from which I received phone call, but I disclosed the name of the caller. House of Milord in the FIR, Milord, there is also no disclosure of the name of the caller. House of Mehtab is not surrounded by any boundary wall. His house was made of wood and tin with tin shed roof. There are doors and windows in the house. I cannot say registration number of the vehicle by which wife of Mehta was taken to the hospital. I could not notice any mark of sandal or shoes on the floor covered by the blood. Now, Milord, these are general lines. Milord, the line from the bottom, third line from the bottom.
Yeah.
I lodged a complaint at the PS on 28/7/2023 at about 10 to 10:30 a.m. Well, this was the time when the FIR written complaint was submitted at the police station and FIR was registered. Next day, 10 a.m. in the morning. Now, Milord, next witness is Milord, the manager of the homestay, where Milord, these people had stayed one day earlier to the incident. So, Milord, let us keep this for now because he has admitted in 313 that he has stayed there.
So you don't dispute this?
Yes,
that
yes. Milord, let's go to 6. Very important witness, Milord, Raju Islam. Milord, he says he is a neighbor and he also allegedly apprehended the accused persons. He says that. Now, Milord, I know Mehtawala Ansari and his wife Momita Dash as my neighbor. Mehtab Alam is not alive. He was murdered by his nephew Aftab Alam and his 5 associates. Out of them, 2 were female. My house situates 500 meters away from the house of Mehtab Alam, almost half kilometer from the house of place of occurrence. I knew Aftab Alam, nephew of Mehtab Alam, since his childhood, and I saw him in the house of Mehtab Alam. Aftab Alam is present in court today and identified. On 27 July 2023, at night, while I was sleeping in my room, suddenly I heard screaming from outside. I came out of my room and I heard from my next door neighbor Abdul Latif that dacoity took place in the house of Mehtab Alam and the persons who committed dacoity also killed Mehtab Alam. Milord, 500 meters away he was staying, he heard Milord screaming. But Milord, the next adjacent houses, Milord, they heard nothing. Now, Milord, I also heard that sons of Mehtab Alam were missing. Thereafter, myself, Abul Hassan, very important line, myself, Abul Hassan, and Nirod Roy went to the house of Mehtab Alam and found that Mehtab Alam lying dead on the floor of his room with multiple bleeding injury, and the floor of the room was full of blood. I also found that the wife of Mehtab Alam lying injured with multiple bleeding injury all over her body. So, this is the thing. He says, I went there, I found Mehtab Alam. He also finds Momita there, lying.
That is contradictory to Momita's.
To Momita's and all others.
Momita
You will find some.
must have by
Yes.
then must have escaped to somewhere else.
Yes.
Jumped out of the window.
Yes.
He overdid it.
Yes.
Sometimes people feel important when they are in the witness box. That is a common psychology of witnesses. And otherwise, there is nothing in their life, probably. Nothing to get importance. So we'll have to give some discount also. We are speaking against you. I mean,
Yes,
there may be some discrepancies which, but yes, but definitely it's a discrepancy. Definitely. Yes. Let us continue.
Yes. But then he says, we immediately arranged one Maruti van. De facto says ambulance. He says Maruti van owned by Abul Hossain and sent her to Dhupguri hospital, and the vehicle was driven by Nirod Roy. Myself, Abul Hossain and 2 other persons accompanied her to the hospital. Very important, Lord, this part. At that time, Momita was conscious and she told us that 6 persons, including Aftab Alam, entered into her house for committing dacoity. Out of them, 2 were female and all the accused persons were talking in Hindi language. Momita also told us that the accused persons killed her husband with knife and also tried to kill her with knife. At that time, she was not aware where her sons were. Due to her serious condition, Momita was referred to Shodor Hospital, Jalpaiguri. Thereafter, myself, very important from this point, thereafter myself and Abul Hossain, Nirod Roy and 2 others were returning home by our Maruti van. We parked our vehicle in front of a tea stall at Deomali under PS Dhupguri for taking tea. At that time, it was 3 to 4 a.m. At that time, we found Aftabalam and his 5 associates were walking towards Dhupguri from Angravasha. We found all are barefoot and there were apparels and their wearing apparels were muddy and their hands are stained with blood and hands are covered by handkerchief. Out of suspicion, we apprehended them and started interrogating them. At that time, they tried to flee away by pushing us. We started chasing them and informed police of Dhupguri PS. I also called my villagers. Local villagers came out after hearing my shouting. We managed to apprehend all 6 accused persons. Thereafter, all the accused persons confessed their guilt and further confessed that they entered into the house of Mehtawalam for committing dacoity and they killed Mehtawalam. They also confessed they tried to kill Momita and her sons. After few moments, police of Dhupguri PS came to the spot and we handed over the accused persons to police. All the accused persons are aged about 18 years and above. Now, my lord, from this evidence, it is clear, my lord, they chased, they apprehended all 6, and then police came, my lord, handed the accused persons to the police then and there. So, my lord, it's 3 to 4 a.m. By then, my lord, the accused were already given to the police, handed over to the police. Now, my lord, cross-examination. My lord, I must admit the cross-examination is very bad for this witness. My lord, so important witness, only one line cross-examination. My lord, there is a judgment of the Supreme Court where, my lord, this year, Supreme Court said legal aid does not mean, my lord has seen that. My lord,
This was on legal aid.
This was legal aid.
That's it.
The Legal Aid Defense Council. But my lord, I felt very, my lord, what to say after seeing this. Because so important witness and so many things in the chief, but nothing in the cross.
Very, I mean, potential
Yes.
chief.
Yes.
And-
Yes. Anyway, my lord, in the cross, he says, I do not know the name of the father of Aptawalam. I do not know his address. I have no fixed job. My family consists of mother, father, and one brother. Rabiul Alam, Tofiqul Islam, Abdul Latif. are
Sure,
my neighbors.
entirely irrelevant, in fact.
Nothing, not relevant.
Whether he knows his father, brother,
Not
mother,
relevant.
entirely immaterial.
But anyway, my lord, this whatever he has stated in the chief, lordship will find gross contradictions with the subsequent witnesses. Next, my lord, PW7. He is the caretaker.
Might be that maybe one of the reasons, Dr. Chaudhary, why he was not cross-examined too much. Because in cross-examination, he would have an opportunity then might have been to explain
correct
away
himself,
his,
yes.
that may be one of the things. I mean, either very good counsel or very bad counsel. Either of the two. Cannot be in between. You just left the contradictions there in the chief so that, but they, at that point, yes, there were witnesses of others previously also.
Yes, yes.
So he knew about the other witnesses.
Yes.
So did not permit him to allow him to explain away the, maybe, let us see.
PW7 is the caretaker of the homestay, my lord. He is also not relevant so much because I am admitting that I have stayed there one day prior.
Very good.
My lord, PW8. Rafiq Ali, page 69. Lord, he is one of the member of the Dhalai team whom Momita says
Took to,
yes, and also a Caesar witness to the recovery of the offending weapons. Now, my lord, he says, I know Mehta Walam Ansari and his wife Momita Das as my neighbor. Mehta Walam is not alive. He was murdered by his nephew Aftab Alam and his 5 associates. Out of them, 2 were female. My house situates adjacent to the house of Mehta Walam. Lordship will not find his house in the sketch map. I knew Aftab Alam, nephew of Mehta Walam, since his childhood, and I saw him in the house of Mehta Walam. Aftab used to reside in Delhi. Aftab Alam is present in court today, identified on 27th July 2023 at about 2 hours at night, while myself and my Dhalai team were coming back from Joygaon and passing through the house of Mehta Walam, we found that one female was asking for help and her hands were full of blood. When we came out from our vehicle and went towards her, I noticed it was Momita Das, wife of Mehta Walam. We found her with multiple bleeding injury all over her body. Immediately, I called my neighbors and arranged one Maruti van and took her to the Dhupguri Rural Hospital. She disclosed to me that Aftab Alam and his 5 associates entered into their house and assaulted her with knife, and they also assaulted her husband by knife. She requested me to save her husband, who was still in the house, and she did not know where the children were. Immediately, I went to the house of Mehta Walam and found him lying dead on the floor. Now, one thing, my lord, when he takes Momita on the vehicle to the hospital, my lord, how come immediately he went to the house of the Mehtawalam? Next line, my lord. Immediately I went to the house of Mehtawalam. This might be.
No, before taking her to the hospital,
No.
he says immediately I called my neighbors, arranged one Maruti van.
And took her
He
to
dis-
Dhupguri. Took her to Dhupguri Rural Hospital. She disclosed to me that Aftab and his 5 associates entered into their house and assaulted her with knife. And they also assaulted her husband by knife. She requested me to save her husband who was still in the house and she did not know where her children were. Immediately I went to the house of Mehtawalam and found him lying dead on the floor. I did not find his children, and after searching, we found them in the house of Ashwini Roy. After some time, I received a phone call. Now, my lord, he took Momita to the hospital. Momita said he went to the house of Mehtab. He also went to the
So many
house of Ashwini.
stopovers. I mean.
And then, my lord, after some time, very important, after some time, I received a phone call from Abul Hossein, who informed me that some boys and girls were found and apprehended at Murgi Hotel, Devmali, and their wearing apparel were muddy. When I reached there, I found Aftab and his 5, and then he reaches there also, Lord, at the same time.
Probably he also had dinner and coffee, tea, something like that on the way. He did so many things while taking her to hospital.
Yes, my lord, I'm coming to that, but if
He also had dinner in a
No, no.
hotel.
dinner,
Only that is left. এই হিরো হওয়ার ইচ্ছেটা না উইটনেসদের অর্ধেক কেস খারাপ করে দেয় উইটনেস হিরো হবো অর্ধেক প্রসিকিউশন কেস খারাপ
ডিনারের কথা বলে
ইয়েস
But then he reaches, as soon as he receives call from Abul Hossein, who is the next witness, PW9, he then and there he reached there, he finds Aftab and 5 associates wearing apparels were stained with blood. When I asked Aftab why he committed such offense, he disclosed that they came to the house of Mehtab for committing dacoity, and as they were resisted by Mehtab and her wife, they compelled to commit such offense. Thereafter, police came to the spot and we handed them over to police. Police also came to the house of Mehtab and performed inquest in my presence. Lord, one thing, PW6 says, when the 5-6 witnesses were apprehended, they tried to flee. Lord, they were chased. Thereafter, police was called and handed over. Lord, this version is not present in Rafiq Ali's statement. Rather, Lord, the Rafiq Ali's presence there, at the same time, Rafiq Ali's presence in the house of Mehtab and taking Momita to the hospital, my lord, all 3 things together, my lord, is very confusing and doubtful. Next, my lord. Next, the seizure part comes. On 8th August 2023, at about 4:30 p.m., while I was proceeding towards Dhupguri, I found police with the accused persons at Shonakhali Forest. I went there and found that police recovered some knives and other articles inside the forest area. At that time, Abul Hossein was also with me. We both put our signature on seizure list prepared by police as witness. Accused persons also put their signature as witness. These are my signatures on 3 pages. Now, my lord, the question is,
No, we don't understand this.
Lord, he
Where
directly,
did he see the accused persons? He says he went to Murgi Hotel and saw them there.
that was the first part of arrest. This is, my lord, recovery of the offending weapon.
Oh,
8th August.
All right.
My lord, all of a sudden he was going towards Dhupguri. He finds police with the accused person at Shonakhali Forest. He stops there, and my lord, he witnesses the seizure. His name is there in the his signature is there in the seizure list. My lord, will find page 11 of part 2.
That incident happened when?
Incident happened on 8th August.
Same day.
No.
No.
8th August.
The murder occurred when?
On 27th, 28th of July. Yes. Almost after 10 days.
And by coincidence, he was also going nearby when.
Yes.
And those articles were identified by the witnesses.
Yes.
And Lord, the most important thing, Lord, they were apprehended by the police as per this witness statement on 28th July itself. Lord, recovery as per the prosecution case is effected on 8th of August, Lord, after 10 days when they were in custody.
What is the prosecution version? The recovery was made upon the accused statements.
Yes. Leading statement, but if lordship sees the statement, lordship will find it is not at all a leading statement. Because leading statements are not taken in the police custody. Thereafter, on the basis of that statement, the recovery is effected. From the statement itself, lordship will find that it is a post-seizure statement. Post-seizure statement, yes.
Actually, it is.
Milord may see once if lordship desires so. Page 28, Milord. It says, on being asked by you, I would like to say that on the day of incident, that is about 2 to 2:30 in the morning, I along with my 5 friends had entered the house of my uncle Mehtab Alam Ansari with an intention to commit dacoity, as I knew that my aunt used to keep valuables in her almirah unlocked. But as they woke up from sleep, I and my 5 friends had to stab my aunt and kill my uncle, and we fled away after grabbing some cash from drawer. On being asked by you, I brought you to the place, showed the bag where I had kept the knife, the stolen money, a piece of rope, a vest, and a partially torn scarf which I had hidden in a bush in a forest. You seized them all after I showed and identified to be used by me. So, my lord, this is the statement. And this statement shows, my lord, this is the post-seizure statement. My lord, normally, my lord, the process of seizure and section 27 of the Evidence Act says that when a witness is willing to cooperate with the police and voluntarily wishes to give a statement, only then a statement can be recorded. But prior to recording the statement, 2 independent witnesses has to be called in the police station, in whose presence the witness will give his disclosure statement. And thereafter, on the basis of that statement, the recovery has to be effected.
This at best refers to a pre-seizure statement. I mean, it says in past tense.
Yes.
That on being asked by you, I brought you to the place, showed the
Yes.
bag. So on being asked by you, so
My lord will find in subsequent statement in the IO statement, the IO says that I have recorded the statement at the place of occurrence. Sorry, at the place of seizure.
Seizure.
Place of seizure. So, my lord, this is one of my point that the seizure, the offending weapon, recovery of the offending weapon is not at all in the process laid down in the law.
So why is this protection given? So to ensure that these are not planted.
Yes. Yes.
Because the witness can be taken anywhere and the things planted and
My lord.
made to say. So
My
that is the premise of the
Lordship. Yes.
27 itself stipulates that 2 independent witnesses have to be taken.
No, my lord, that comes out from the judicial
Judgments.
Yes.
So we'll look into those judgments.
Yes, yes. Next, my lord, the cross-examination.
Yes.
On behalf of the defense. He says, we were 10 to 12 members of our Dhalai team. Myself, Abul Hossain and Patanu Roy, my lord, the Patan Roy, whose
Patan
name
that
taken,
time, yes.
yes, went near to Momita when she was asking for help. I knew Mehtab and his family since long as my neighbor. We were proceeding through village road. Myself, Abul Hossain, Nirod Roy, and many others entered into the house of Mehtab at 2:30 hours. And at that time, accused persons already fled away. Police interrogated me when the dead body was taken to the PS from the spot. During inquest, I stated to the police that when we were returning home through village road, we found Momita Das asking for help. I did not inform the local police when I saw the dead body inside the room. Abul Hossain, Raju Haq, Nirod Roy and others apprehended the accused persons near Murgi Hotel. At that time, I was in the house of Mehtab Alam. Now, my lord, again here says at that time, I got the
No, can it be reconciled? Let us see. After some time, he says previously, after some time, he received a phone call. First, met Momita, took her to hospital. Let us give the benefit of doubt to him. Took her to hospital after. Immediately, he went and found Mehta.
Well.
Then got a phone call, learned that they were at Murgi Hotel, Deomali, and went there and met them and went so far as to ask them questions why did it and all.
But
Now he says at that time, when they were apprehended, might have been they were apprehended at a time when he was at the house of Mehta, then got a phone call and met them there. That might be.
my lord, I presume that, but
I mean, it's not mutually destructive. And it may happen. I mean,
may happen, may happen.
not that this itself belies the previous statements.
No, correct.
Might be, might be. Got the call and then went there. But at the
Yes,
time of apprehension, he was not there.
That is what he says.
He
That
went there to ask the questions, the philosophical questions, why they did it and what gain would be. Yes.
I got the information from then at about 3 hours. I cannot say the time of apprehending by the local people. Police took the dead body at about 2:45 hours on 28 July 2023. Now, Lord, when I found the accused person at Murgi Hotel, I did not find these knives in their possession. I did not find any stain of blood on the knives. Sonakhali Forest, yes.
No, but previously said wearing apparel were stained with blood.
Stained.
So now he says knives were not there and knives were not stained.
Stained.
Not contradictory again.
No. Sonakhali, and my lord, this wearing apparels, as per this witness and also other witness, it was stained with blood. My lord,
Yes.
the wearing apparels were never sent to forensic for examination.
No,
There is no
wearing apparel
forensic
were
evidence.
exhibited. I mean,
No,
those were not.
no, no.
All right.
ওগুলো কিচ্ছু করেন
Nothing is there to show that they were sent to forensic.
No. No.
All right. Yes.
Lord, Sonakhali Forest is about 2 kilometers away from the house of Mehtawala. Murgi Hotel is 3.5 kilometers away from the house of Mehtawala. I did not find my signature or any label on the seized nylon rope. There is a pathway about 200 meters away from the place of seizure inside Sonakhali Forest. At the time of seizure, accused persons were also present at the spot. They identified the places where the seized articles were kept concealed by them. At the time of recovery, I was standing at a distance from the place of recovery.
A little distance.
After when his 2-3 associates identified the places from where the articles were recovered, there was no private houses inside the forest.
Obviously, there were no private houses.
But IO says there is a village. There is a village just adjacent to the forest.
To the recovery place.
Yes.
Oh.
Now, my lord, next witness is also one of the seizure witness. His name is Abul Hossein. My lord has heard his name in many statements.
Previous ones.
Yes. Now, my lord, the most important thing which I have noticed last night, my lord, that the statement of Rafiq Ali and statement of Abul Hassan, my lord, from the first line to the third bottom line.
Copy paste.
Copy paste.
It was asked from the same, the chief, examination chief. Maybe copy paste.
My lord, same day both were examined. There is not even a change in the my lord, comma, full stop, nothing. It entirely copy paste. And my lord, that is where the contradiction comes. My lord, I'll show your lordship. My lord,
The contradictions were also copy pasted.
yes, yes. But he also says his house is adjacent to Mehtawala.
Oh, his house.
Yes.
All the Dhalai party people house are.
Yes.
All right. Your learned friend seems to agree for the prosecution. Yes.
So, my lord,
Very
he
well.
also- he
Might
also-
have been, yes.
my lord, he also says that he took Momita to hospital by a van. Immediately, we called our neighbors and arranged one Maruti van. Milord will start from the third line from the bottom because
Yes, unnecessary.
Yes. Nirod Roy was the driver of Maruti van.
Hmm.
Third from the bottom.
Yes.
Thereafter, myself and Nirod Roy were returning home by our Maruti van. We parked our vehicle in front of a tea stall at Deomali under.
So our guess was correct.
Yes.
No, but this is not after the incident, we hope.
This is after the incident.
They stopped at a tea stall.
Yes, after dropping Momita in the hospital, they while returning back, they dropped at a tea stall and Devmali.
Maybe while going also they might have had. Don't know.
PS
They're losing confidence in this
for taking.
Halai party.
Yes. At that time, it was 3 to 4 a.m. At that time, we found Aftawala and his 5 associates.
Yes, you are right. Returning home.
Yes.
Right.
5
At that time-
associates were walking towards Dhupguri from Angra Bhasha. We found all are barefoot.
Same, exactly
Yes,
same.
wearing
It is actually a copy paste.
Milo. Milord, all these witnesses, Milord has found that. Yes.
But the cross examination is also a copy paste. Legal defense counsel who is দেখুন আপনি দেখুন question same question দুজনকে করেছে exact copy paste নয় না একটু difference
Milord, some variations are
some
there.
variations are there না ফিরে আসুন আপনি ওই ঢালাই পাটিটা হচ্ছে that was page 66 the previous one
Previous
Dhalai
one was,
Patti?
Milord, page 69.
cross examination
Cross examination is page starts from 70.
আচ্ছা no there's a difference
Yes.
anyway very well
So, Milord,
ওটা তার আগেরটার সঙ্গে কপি পেস্ট ওই কয়েকটা কোশ্চেনই ছিল যা জানতো তাই কোশ্চেন ডিফারেন্স আছে কোন জায়গাটা ল্যাঙ্গুয়েজটাও তাই দেখুন খালি পায়ে আংলাটা যাচ্ছিল এটাও তো দেখুন এটা আসছিল ডিফারেন্স আছে কিছু ভেরি গুড ইয়েস
Milord, Milord, let us
কেউ পারে
start.
কপি চিফ হতেই পারে কপি ইয়েস
Milord, let's
পতন
start.
রায় দা পতন রায় no we have not we have jumped a step probably
Abul Hosan, 73.
73 right yeah, that we have seen that is the
Milord, no, one thing is important.
acha very good yes
Milord, 5th line from the top.
hmm
7th line, Milord. Thereafter, we inform the local PS. Thereafter, we inform the local PS, and after few moments, police of Dhupguri PS came to the spot, and we handed over the accused person to the police. Now, Milord, all of these witnesses says that then and there they have handed over the accused persons to police. Milord, police IO says, Milord, they were arrested on 10th. So, arrested next day at 10 a.m. I'll come to that, Milord, but Lordship may kindly take a note of.
Arrest memo also. Okay.
no the police says the next day he was arrested
Yes.
next day means
10 a.m. Same day 10 a.m.
10 a.m. If you go by the English calendar, it's the same day.
Same day. Same day 10 a.m.
So where is the difficulty in that? Maybe.
Look, they say that
Oh,
they,
10 a.m. Acha.
10 a.m.
But they
After
say
7
immediately
hours.
after, yes.
So 7 hours.
All right. Maybe that time was 2 to 30, yes. 2 to 30, he was
Apprehended.
apprehended. The local people nabbed him and then police came and all formal arrest might have taken some time. 8 hours, 7 hours, maybe a bit. Yes, very well.
But thereafter, after exhibit 20 and 21, Lordship will find the next line. I also put my signature. He is also a Caesar witness to the offending weapon. Caesar to the offending weapon. I also put my signature on Caesar list dated 8/8/2023. These are my signatures. Let the signatures be marked exhibit 8/8 so and so. Now, my lord, he doesn't explain the circumstance as to how he went to the place of Caesar. Neither he was called by the police, not it was a coincidence. How, my lord, he appeared at the place of Caesar, my lord, it is still unknown to the my lord record. So, my lord, the contents of the Caesar list was not proved by him. Only the signature which he has put, my lord, has been proved by him.
His witness as to the recovery lends a sort of sanctity to the otherwise vitiated, you say, Because if his evidence can be vitiated by you by showing that it is too much of a coincidence that he was here, and his evidence is taken out, then it remains only the police who say that recovery took place.
My lord, there are two.
Others also.
Two witnesses, this PW9 and PW8.
Both of them were part of the Dhalai party
Ah,
as well as there at
the-
the time of recovery.
yes. And my lord, the circumstance under which they went to the place of Caesar Miller is unknown. One says it was coincidence, he was going to Dhupguri, another says nothing.
Hmm.
Now, my lord, the cross-examination. We apprehended the accused at about 4:30 to 5 a.m. on 28 July 2023. Aftab was wearing black t-shirt and black half pant. On 8th August 2023 at about 4:30 to 5 p.m. police recovered seized articles from Shonakhali forest in our presence. At that time, Milord, in the cross, this question was put to him. Milord, this should not have been put to him, but it was. At that time, myself, my friend Pintu, and the accused persons were present at the spot and identified the places from where the articles were recovered. So new thing comes, Milord. He doesn't talk about Rafik and
Rafik may be Pintu, we don't know.
we cannot presume with respect to
No,
the
cannot presume.
Yes, Milord, Pintu is a new character which comes here, Milord.
Hmm.
With respect to the Caesar, there is no signature of Pintu in the Caesar list. Neither police speaks of Pintu. But there was no private residence at that place. Generally, public do not use that pathway inside the forest. In the morning on the next day of the incident, police interrogated me. Thereafter, my lord, general denials.
Is the allegation that they also took some things, articles from the house?
3,500 rupees. That was recovered along with the offending weapons. Next, my lord, PW10, Paton Roy, my lord. The one, yes.
Yes.
The one Momita named. He was also a member of the Dhalai team. But he says, I know Mehtab Alam Ansari and his wife Momita Das as my neighbor. Mehtab Alam is not alive. On 27/7/2023 at about 2 hours at night, while myself and my Dhalai team were coming back home from Joygaon and passing through the house of Mehtab Alam by our pickup van. On the way, we found that one female was asking for help and her hands were full of blood. When we came out from our vehicle and went towards her, I noticed it was Momita Das, wife of Mehtab Alam. We found her with multiple bleeding injury all over her body. She disclosed to us that her Bhagina and 5 associates entered into their room to commit dacoity and committed murder of her husband Mehtab. She also disclosed that she did not know where her children were. Out of them, 4 were male and 2 were female. Immediately, we called our neighbors and arranged one Maruti van and took her to Dhupguri Rural Hospital. Nirod was the driver of Maruti van and 2 or 3 villagers accompanied Momita to hospital. But he doesn't name Abul Hossain. Thereafter, myself and Ranjit entered into the house of Mehtab Alam. Again, a new person comes, Ranjit Milord. Till now, he was nowhere there. In the house of Mehtab Alam and found floors of the rooms were full of blood and Mehtab lying dead on the floor. Thereafter, we informed the local police. Prior to the incident, I saw Bhagina of Mehtab in his house. He used to reside with Mehtab since his childhood. Said Bhagina of Mehtab is present in court today, identified. I do not know his name. Witness pointed towards the accused on dock and disclosed that boy is the Bhagina of Mehtab. He doesn't take name, only Bhagina and points towards Aftab. Next, we have the cross-examination. Momita disclosed about her Bhagina to commit the offense of dacoity, but she did not utter his name. I used to call her Bhagina as Babu. I saw him during his childhood, but I have no idea his age. But his age might be 7 to 8 years at that time. I cannot say whether that boy was the Bhagina of Mehtab or Momita. I cannot say whether Momita has any other Bhagina. After visiting the house of Mehtab, I came back to my home. Now, my lord, very important. Abul Hossain and Rafiq Ali were not with me at the time when we were returning home from Jaigaon. Similarly, he denies Abul and Rafiq being a part of the Dhalai team. And
Returning home from Joygaon.
Yes.
Joygaon is the place of occurrence.
No.
No,
Dhupguri.
the recovery place.
Jaigaon is a different place. They were coming from Jaigaon to.
But it is not clear they were returning home from Joygaon means when.
Milord, the Dhalai team were coming back, as Momita has stated, Dhalai team was coming back, and at that time they were stopped by Momita. So Dhalai team was at Joygaon, they did their job, they were coming back to their house at Dhupguri.
Did Momita mention Joygaon or no?
No.
He only saw that it
They
was
were
coming.
coming back. Milord, all of them said that Joygaon was the place where they went for Dhalai, perhaps. And Milord, they were coming from Joygaon.
Oh, right. Right. Yes. Yes.
Milord, next witness is PW11 Ranjit. Milord, the new person's name taken by Paton is the PW11 Ranjit Tikka. Perhaps, Milord, because only name Ranjit is there. So, PW11, page 76. But he says, though he says that he has no personal knowledge, but narrates the incident. I know Mehta Walam and his wife Momita Dash as my neighbor. Mehta Walam is not alive on 27/7/2023 at about 2 hours at night, while myself and my Dhalai team of 14 members, including Paton Abul Pintu, were coming back home from Joygaon and passing through the house of Mehta Walam by our pickup van. On the way, we found that one female was asking for help and her hands were full of blood. When we came out from our vehicle and went towards her, I noticed that it was Momita Dash, wife of Mehta Walam. We found her with multiple bleeding injury all over her body. She disclosed to us the 4 male and 2 female persons are inside of her house to commit dacoity and they murdered her husband. They came from outside. Immediately, we called our neighbors and arranged one 4-wheeler and took her to Dhupguri Rural Hospital. Abul accompanied Momita to hospital with 2 others.
No, apparently, he says that he called his neighbors and they arranged a 4-wheeler.
Yes.
But this is also somewhat discrepant from the Dhalai team coming.
Not every
Momita approach. As per Momita, Dhalai team vehicle was coming. She stopped them.
Yes.
She told them that something has happened. They went, giving their best case.
Lordship.
They went in, then took her via the accused place and took her to the hospital.
Lordship.
But this person says that they called the neighbors and arranged a 4-wheeler. Very well. Let us see. Yes.
But every witness has come up with a new version. So immediately they came from outside, immediately called our neighbors, arranged one 4-wheeler and took her to Dhupguri Rural Hospital. Abul accompanied Momita to the hospital with 2 others. Thereafter, myself and 3-4 persons of our team entered into the house of Mehtab Alam and found dead body of Mehtab lying on the floor. We could not find their children inside the house. We also found blood on the floor of the rooms. Thereafter, we informed the local PS. I do not know the names of the persons who murdered Mehtab. I cannot identify the person who killed Mehtab. Next, Milord, cross-examination. When I entered into the house of Mehtab, we could not find any person there. Momita was standing on the road. Look, this is very important. Look, see, he says Momita was standing on the road while Momita stopped the Dhalai. There are houses on both sides of the road where Momita was standing.
The Momita had come out and might have been outside.
But she was standing on the road. Now, Milord, next line.
To stop
There
the-
are houses on both sides of the road. So, Milord, without calling those the members present in those houses, she was standing on the road for someone to come and she to stop them. So, Milord, this is also a bit, Milord,
Standing there for 20-30 minutes.
yes, Momita was standing there for 20 to 30 minutes.
No, Momita's version is she was hiding in Ashok Ray's house.
She was hiding beneath a wall, and thereafter these persons came, they rescued her and took her to Ashok Rai's house.
Very well. Yes.
Milord, page 77, next is PW12. He is
They
the doc-
rescued her and took her to Ashok Ray's house, but then they themselves took her to the hospital, as per Momita's.
Yes. Yes.
What was the role of Ashok Ray?
Ashok Rai was a neighbor. He was
Maybe might have
But
The
his
knee-jerk
house-
reaction was to take her to
Yes, but
neighboring.
Ashok Rai's house is not present in this
But
case.
that is not there in there. Very well. Yes.
But PW12 is the doctor who recorded the dying declaration. But he says, presently I am attached to Eveland Nursing Home. On 1st of August 2023, I was attached to the same nursing home. On 1st August 2023, patient namely Momita Das, female, 35 years, wife of Mehta Balam, was admitted in our nursing with multiple injuries all over her body. As per
1st of August.
1st of August is.
No, incident was of 28th of July.
20th of July, first she was taken to rural hospital,
Oh,
then
then,
Southern hospital,
right.
then Eveland. And as per requisition received from Dhupguri PS, I recorded dying declaration of the patient in presence of Konika Rangdar, sister nurse of that nursing home. I recorded the statement, what patient disclosed to me, and after recording her statement, the patient put her signature on her statement. After being read over and explained the contents of the statement, the patient put her signature. The patient was mentally fit to give statement, though I did not mention it in her statement. This is the signature of the patient, Momita Das. I also put my signature on the statement and it bears official seal of the nursing home.
Why go on calling it a dying declaration? It is meant to be a dying declaration, but anyway.
Then the cross-examination. At the time of recording her statement, there was no such apprehension that patient may die at any time. And while recording her statement, the patient was mentally fit and stable.
Why was it at all called a dying declaration in the first place?
Since the police asked him, he did it.
Yes, right. That is his.
I recorded the statement of the patient only to comply the direction of the police.
Yes.
Neither any police personnel nor any family members of the patient was present at the time of recording the statement. So Milord has gone through the contents of the statement. The first August statement. Next is Milord Nirod Roy, the driver who drove the vehicle and took Momita to the hospital. PW 30. He says, Milord, I know Mehta Walam and his wife Momita Das as my neighbor. Mehta Walam is not alive. Mehta was murdered. I knew Aftab Alam since his childhood as he used to reside in the house of Mehta. Aftab Alam is present in court today, identified. On 27/7/2023, at about 2:33 at night, I received a phone call from one of my neighbor and informed me that Mehta was murdered and asked me to come immediately with the Maruti van of Abul Hussain near the house of Mehta. Within 10 minutes, I reached the spot with Maruti van and found Momita with multiple bleeding injury all over her body. Thereafter, myself, Abul Hussain, Patan Rai and two others took Momita to Dhupguri hospital. On the way, Momita disclosed to us that Aftab and his 5 associates, out of them 2 were female and 4 were male, entered into their house and murdered her husband with knife. They also assaulted her with knife. All 6 accused persons were armed with knife. After admitting Momita in the hospital, we returned back home. Now, we had no evidence with respect to the apprehension of the accused person.
We'll continue tomorrow. But tomorrow, Dr. Chaudhary, just be a brief. I mean,
But
just
tomorrow
point out that because we'll have to, otherwise we can't conclude before.
I'll also file my written notes about it.
That will be easier for us. Give a copy to them so that they can also deal with that, Mr. Chakravarti.
Lordships, before your Lordships likes, may I just...
Let us pass the order first. Heard in part for further hearing tomorrow. Yes.
Lordship, serial 23, it was heard by your Lordships the day before yesterday. It was kept returnable, that GST matter.
Oh, yes.
It was kept returnable today, Lordships. So Lordships will take it tomorrow. Maybe some preference, Lordships, because my argument, Lordship, is complete. The state has to...
Yes. Remember that. Let us stapler like that. Staple kore to ঢুকে দেবেন. We'll think it over. If not tomorrow, then some other day, because this death reference we're trying to finish.
Grateful. No.
Very well. We'll try to be as quick. Yes, very well. Let us consider that. This is item number?
Item number 23 of today's list, Lordships.
23 টা একবার লিস্ট ছাড়ার আগে জিজ্ঞেস করে নেবেন তো, ওটা একটু রেফারেন্স দিতে হবে। আগে ডেথ রেফারেন্স শেষ করতে হবে।
Much obliged. Grateful to you.
শুনানি করে দিয়েছো।
Grateful.
So, I seek leave to mention two civil revision applications here, number 121 of 225.
Permitted to mention few matters, Lordship. In one matter, Lordship, today's item number 25,
Yes.
that is claimant appeal, and the insurance company also has filed in the year 2025. So I want to tag both the matter.
Give
And
that, yes.
5 new appeals, Lordship.
New appeals don't mention, because
Stay is highly required because the department is facing the execution.
then you file the applications, we mention application, the heading will be application then. We can take up the applications only. The one which is to be tagged with 25, write the item number, today's item number.
25, Lordship. This is.
So that will be tagged with the other appeal. Let us see if it is, whenever it comes up.
And others application.
Others, write application and then hand over, yes. Yes, any other mention?
Your Lordship, may I permit you to mention one matter? It's a CO application.
Yes, hand over, yes. Appeal hearing? No, next circuit. Application, yes,
Lordship, may I be permitted to mention one CO matter?
yes. We'll come to you. CO, yes, yes,
May I permit to mention one CO matter?
yes.
Monday. And we can.
Whenever the file comes, it will appear, yes.
May I be permitted to mention more matter for inclusion in the list?
What is
Appeal
it?
arising out of
Appeal hearing?
my lord, appeal. hearing.
Hearing, we are not adding any further. We can't reach. Appeal hearing, matrimonial,
It is from the motor vehicle award.
no further addition. We won't be able to take up so many. Appeal hearing, we cannot. Yes, next. I will call the list. Application উনি যেটা দিলেন সেটা application heading এ যাবে আর একটা শুধু 25%. Yes. You are for the petitioner.
The affidavit in reply.
Opposition you have filed already? Yes, you have filed. So this is appeal has been admitted. Section 5. Section 5. What is the delay?
See, as per there, 284 days.
No, let them explain first. Yes. Yes.
My para 8 of my reply, my lord. There is a delay of 285 days, my lord, as per
Right.
my condonation application,
Yes.
right? In para 8, my lord, I have stated that the petitioner has applied for the certified copy on 5/9/2019 after 6 days from passing of the said appellate order. Then the said order has come to the knowledge of the petitioner. That the certified copy of the said order clearly shows that on 28/1/2020 was the date on which the requisite number of stamps were notified to the petitioner, and accordingly on.
What about the period before that? Why didn't you come to know? It was ex parte.
No, Lordship, this is a contest.
Contested, my lord. The order was passed on 29th August 2019, my lord. The appellate order, against which we have preferred the second appeal, my lord.
29th August 2019.
60 days is
One minute.
6 days we have applied for the.
Yes,
certified copy.
very well, yes.
5/9/29.
What happened after that? Oh, the entire period, the entire period is covered by the certified copy period.
No, Lordship.
My lord. We were notified to file the requisite on 28/1/2020. Accordingly, we filed after 6 days. That is 4/2/2020. We received the certified copy on 5/2/2020. Now, my lord, after which the period of the appeal period expires on 28/4/2020. Because we have 90 days period. But due to COVID-19, we couldn't file it, my lord.
When did you file it?
We filed it on, my lord, filed it on 9th February 2021.
Yes.
And my lord, the Supreme Court has clearly.
Yes, so COVID relaxations are there. Entire period covered.
Actually, I have no objection on that point. Only see, because of that, they have been hyper technical, that their certified copy has been applied for after long period.
After 6 days.
No, get the certified copy, we have.
Or the period after notifying the stamp and that.
I on certificate copy appeal 5/9/2099. Because of the respondent already get the certificate copy in time. But they have been applied for certificate copy on the 20 after 5 days, but they didn't have the requisite, I think. And therefore, they come to the next 4th or say 4th February or 2nd February they have been got. This February to March has not been done. They are in their.
I mean, the period taken by them to put in the requisites.
Requisite is.
No, requisites.
On
Not
2020.
because notifying the period is notifying period and the application period.
28th of January, it was said, yes. And they put in the requisites after 3 days.
3 days. And therefore.
Their application,
they delivered
certified copy application,
and your lordship on the 4th, I think. If I am
5th.
5th. And therefore, 5th to March, 5th January to.
That they need not explain because that is
That
within the
is-
limit.
that
That
is
is a difficulty for you.
That is technical.
Learned-
This has been technical.
Learned counsel for the the affidavit in reply filed to be kept on record. Learned counsel for the appellant appellants argues that the time taken for obtaining the certified copy upon deposit of requisites in time, comma, took the limitation to April 28, 2020. First up, since the pandemic within bracket COVID-19 bracket closed restrictions had started by then, comma, the appeal could not be filed before February 9, 2021. First up, it is submitted that the entire period of the of limitation which passed in between was covered by the period during which the Supreme Court, comma, by various orders, comma, had been granting relaxations regarding limitation for preferring appeals, suits, etc. First up, next para. Learned counsel appearing for the appellant respondent submits that that the period in between obtaining the certified copy and preferring the appeal has not been properly explained. Full stop. However, comma, under the Limitation Act, comma, there is no necessity for the appellant to explain the period before the expiry of the limitation period. Full stop. As such, comma, since the entire period of the limitation was covered by the COVID relaxations, comma, this court is of the opinion that sufficient explanation for the delay has been furnished by the appellants. Accordingly, can 1 of 2021 is allowed, comma, thereby condoning the delay in preferring SAT 7 of 2021. Full stop. The appeal be placed for hearing before the appropriate division bench of the circuit of this circuit for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes.
Lordship, kindly in this period next week for only admission.
Tomorrow.
Admission, so that has been point of admission.
Tomorrow.
Tomorrow.
Yes, yes. It goes from this court, remains in this court. Yes. কালকে লিস্টে দিয়ে দেবেন order 41. Please give your appearance, Mr. Rai Mohasai and whoever is appearing with you, and Ms. Sarkar also. Yes. What is this?
Well, this appeal was admitted earlier by the Honorable Division Bench.
Stay
The
application.
Lordship was also pleased to take it up yesterday and correct the order. Milord, today, Milord, we have only prayed for the stay since the stay application is.
What is the nature of the decree?
Decree, Milord, eviction decree. Eviction.
Should direct you to file opposition for occupation charges?
My senior is in another court, he is doing another matter, kindly pass.
No. In view of the appeal having already been admitted, comma, a strong prima facie case has been made out for grant of stay. Full stop. Accordingly, there shall be stay. Can two.
Can two, Milord.
Both the courts below, lost in both the courts below?
Yes.
There shall be stay of operation of the impugned judgments and decrees of both the courts below till disposal of the application. Full stop. The respondent shall file his affidavit in opposition to the application within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. Liberty to the parties to mention the application for inclusion before the list of the appropriate bench in the next circuit after the timeline for exchange of affidavits is over. For sub next para, it is made clear that the question of imposition of occupation charges as a condition for grant of stay is kept open for being decided finally at the time of hearing of the application.
So far as the main appeal is concerned, the directions of paper books has yet not been.
Very well. In view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
It has already been served actually. So that has recorded service is dispensed with.
No, I said in view of their appearance, service is
Yes.
dismissed. Service of the application has been. No, file that affidavit in opposition. প্রথম line তন্ময় করে দিল, affidavit in opposition file to be kept. That is the service of the application. We have directed you to file opposition and kept the question of occupation charges open. You put in your materials for occupation charges in there.
I'm good.
Thank you.
Good.
I have ascertained that the occupational charges were paid till April 2023 month.
So May onwards, what, 3,000?
3,000.
3,000. So you have taken instruction, Mr. Bhattacharya,
Yes,
that is the last. So both of you agree that April was the last,
Yes,
April 20.
2000.
So we'll give you some time to put in the arrears and current occupation charges by 15th. In view of the admission of the appeal on substantial questions of law, comma, a strong prima facie case has been made out for grant of stay. Full stop. You are seeking a grant of stay of
Stay has been granted till the disposal
of the
application.
application.
No, we are now disposing of that, so you have to observe that.
Sorry.
No, but stay of what? Execution has been levied?
No.
No.
Stay
Acha.
of the.
Very well. Very well. Lost in both the courts or one court? Both the courts. Very well. Accordingly, can 1 of 2023 is disposed of by granting stay of operation of the judgments and decrees of both the courts below impugned in the appeal till disposal of the appeal, comma, subject to the appellant going on paying occupation charges at the rate of rupees 3,000 per month, comma, as per the last paid rates before the first appellate court, comma, as a condition for stay, full stop. The first of such current payments for the month of August 2025 shall be made by August 15, 2025, and thereafter for each succeeding current month, comma, by the 15th day of each such month. Full stop. The arrears of occupation charges at the same rate from the month of May 2023 till July 2025 shall be paid by 2 equal monthly installments, the first of which shall be paid by August 15, 2025, and the next by September 15, 2025. First up, it is made clear that in default of any of the above payments, comma, the stay order shall stand automatically vacated without further reference to the court. We have passed directions regarding paper books now. In view of the appearance of the, you are appearing for both the respondents? Sorry, you are appearing for both the respondents? In view of the appearance of both the respondents to the learned advocate, service of notice of the appeal on the respondents is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Payments shall be made in the same account where the.
আচ্ছা একটা লাইন যেখানে ক্যানটা অ্যালাউ করলাম ওই পেমেন্ট গুলো করতে বললাম ওই পেপার বুক সার্টিফিকেশন ঠিক আগে ইন ভিউ অফ দি অ্যাপিয়ারেন্স ওটা তার আগে all such payments shall be made you used to pay at their bank account. Mr. Bhattacharya will ask your client ask you no we will ask you to furnish the bank account, they'll pay directly there. No, you will now pay directly to them. That will be easier. The above payment shall be made directly by online transfer at the account of the appellants, comma, the particulars of which shall be furnished in writing by the learned advocate on record for the respondent to the learned advocate on record for the appellant by July 28, 2025.
Great.
Thank you. Registration application no pass. We filed within time. Then we'll dismiss that for default also.
He is on the way, yes.
Not the?
He's on the way, he's coming.
On the way, exactly where? On the way from where to here? In the court premises? Let us see what case you have made out. What is your name?
I'm
Not at all. No, he's not in the matter, but give us your name. Bhaval. Who is leading you?
Mr. Mayam.
Bhandari.
He's not here in the premises, he's coming.
Then we record your name only.
I'm not aware.
You will be aware soon. The application has been filed within time. The restoration application has been filed within time. Full stop. Upon a perusal of the averments made in the application, comma, this court finds that sufficient reason for the absence of the petitioner on the relevant date has been made out. Full stop. Accordingly, Can 2 of 2025 is allowed, thereby recalling the order dated July 10, 2025, passed in CO number 111 of 2015, along with Can 01 of 2025, comma, where the said revisional application and connected application were dismissed for default, and restoring the said revisional application and the connected application bearing Can 1 of 2025 to their
4 minutes.
to their original file and number. The revisional application along with the connected application shall be listed on July 28, 2025. Restored, Can 1 and the revision will appear together on Monday before me. Yes. Yes. Mr.
Maybe
Bhattacharya.
not. But I for the.
Yes, Mr. Bhattacharya.
Maybe not. Yes.
Yes, what is the matter?
The application of the plaintiff. Plaintiff filed a suit for declaration of title and other consequential relief. They were not hearing that evidence has been concluded of the plaintiff.
Right.
And also defendant. They filed an application for amendment of the plaint. That has been rejected. But for some typographical mistake, kindly see page 26. Page 26. The application for amendment. Kindly see.
26.
26.
Yes.
But first, you will also kindly see the paragraph first. The plaint is required to be amended suitably by deleting the prior of declaration of title and correction of some allied statement in plaint which will be no way change the nature and character of the suit.
What was the original? No,
Yes,
original suit was declaration of title and what?
Declaration
and
of title,
injunction.
Yes, madam.
But you are
But
changing
that
the
is
character of the suit. Have you
No.
alleged? After the evidence, you are changing the entire character of the suit.
After declaration of page 12. Can you see page 12? Declaration of title and consequences. Madam, valuation 65,000.
Not only valuation, Mr. Bhattacharya, you
Yes,
filed
madam.
the suit on the claim that you have title and you are in possession. And
I am not in
now-
possession. Record your kind page 17. Page 17. That's the prior.
Original prayer? Oh,
Page
that was-
17.
Achha, that was also for recovery position.
Yes, madam. All the madam valuation has been put it. Correct valuation.
But
Then,
now
my
you are
lord-
you are trying to remove declaration from the caption.
Yes, only declaration. Now, my lord,
Why are you removing declaration? You are not an
So
owner.
that- I'm not the owner. Admitted I'm the owner. Admitted I'm the owner. Our petitioner is the one owner. Now he gave permission to the PWD authority to store their materials on the assurance about the PWD authority that when they will get an alternative accommodation, they will vacate. They
Why
did
are you
not vacate.
why are you trying to delete the relief of declaration of title?
But
You're
I
not
asked
confident anymore.
I have asked my client also. She says, since I am the admitted owner, recorded owner, there is no need of declaration or title. They ought not to have. What can I do? Then, my lord,
Yes.
then kindly see the first proposed amendment. And there is a typographical mistake of the plot number and area. Though in the averment of the plaint that has been mentioned. Kindly see.
Yes,
But
Mr.
kindly
Bormon,
see,
two aspects of the matter. Why was it rejected? Because after evidence, that's why.
after evidence.
Achha, Mr. Bormon, two things. One is that one of the reliefs they're relinquishing rather. One can always do that. If they wanted some additional relief, we could have understood. They're relinquishing their declaration relief. So one can always relinquish their claim and automatically the valuation will also change. Recovery of possession was originally there. And in the body complaint, if the property is described in a certain manner, that does not tally with the schedule. Now the body will prevail. I mean, they can always. No, they say in the body of the plaint it was already correctly mentioned.
Yes. Yes.
Mr. Bhattacharya, if you go on to saying yes, Mr. Bormon won't be able to argue.
Oh, no, I'm so sorry, sir. But I
Let him say no, and why he says no. Yes.
No.
It was a para 14. Because after filing out our special plea is that is the best land. They have relinquished their share, their predecessor rather, under 7A, they have filed a return,
Para 14, they're trying to delete altogether.
Lordship, inter.
Where is that? Para 14 be substituted by that defendants were in unauthorized. No, previously their sentence was you have no right title possession of the suit property and casting cloud upon the possession and title of the plaintiffs.
Rather, they should have kept this para because after filing of a WS, we have cast cloud upon the title because.
No, the cloud they are not removing. They are saying still say that the defendants who are in unauthorized occupation are bound and liable to deliver a possession.
Para 14 is substituted by the proposed amendment.
Yes, in para 14 they had stated by obviously by Mr. Who have no right, title and possession over the suit property. They have claimed recovery of possession. Therefore, they have admitted your possession. Where is the question of changing the character of the suit? These are minor reliefs. They are relinquishing declaration claim 1. At their own risk, they are doing it. If you ultimately prove before the trial court at the time of trial, Mr.
Evidence is closed.
Your evidence is over also.
No, one evidence has been.
One evidence, but suppose.
Trying to change the area of the land, then.
Now, you can always argue before the trial court that because cloud has been cast over the title, declaration was a necessary relief. And it goes to your benefit if they remove declaration. They let them remove declaration. One plaintiff can always relinquish a part of the claim. A suit valuation automatically differs then.
They have not changed that suit valuation.
They are saying at the top suit for such and such.
It was previously also
65,000. So very well, so what is the difficulty? And the reliefs they are now wanting to remove is that permanent injunction.
Area because their evidence is closed. Then again they
area is being changed.
Point number 5.
Actually, let us see that. That is the most
27 page.
Most crucial allegation. Yes, page 27.
Area was previously 35. Be substituted by 65. They have already closed their evidence.
But the plot number remains the same. Did you take any contention regarding the identity of the property or the measurement of the property in your evidence?
The case is that entire land has been handed over to the state of West Bengal to the department.
So therefore, the measurement does not create any difference. How does it affect your case?
Because we have also filed our register specifying the area which is under our possession.
Now that area which is under your possession, they are now trying to include that area also, or what?
And secondly, the suit is not vented because the administrative.
That will be decided at the time. These are innocuous changes. Suit property remains the same. Where have they stated the previous area? Which paragraph they're trying to change now? Let us see.
Schedule in the schedule to the plaint.
Acha.
Schedule is also defective because in first schedule they have only stated the Khotian number, not the plot number. Again come with another.
Another. Yes, Mr. Bhattacharya, what do you have to say? You are changing the area itself. Then the subject matter of the suit changes. You are muted now. You are muted.
Muted.
Yes, yes,
But
yes.
kindly see page 15 last line. Page 15,
Page
paragraph 30. It is pertinent to mention that at the
Yes.
time of issuing notice such and such, the schedule of the notice LR plot number 799. It would be 7999.
Yes, that
Area
was
was
stated
men-
elsewhere. Yes. stated
Area
elsewhere.
mentioned 0.65 acre instead of 35 acre. It was mentioned 65. Now it would be 65. That word is there, 65. 0.65 acre.
No, but you took a contrary stand. In the plaint, you have stated that in
Yes.
the some notice, LR plot we can understand because you have referred to that in the
Yes,
schedule.
yes. Was mentioned as
7999.
yes.
Was mentioned
instead
as, you said in your original plaint, it was mentioned
Yes.
as 0.65 instead of 0.35, meaning thereby
Yes.
that it should have been 35. You say you erroneously mentioned as 6.65 instead of 35. Now you say it will be 65. Isn't that contrary to your original stand?
But the later 65 was there. That is 65 was there. Later till 11 July 2015.
Area is also different. In para 13, they are saying about 2.
The notice was issued.
Schedule it is
Before
1.9.
filing of the suit. That was 65. That was mistaken mentioned as 35 in the schedule. It will be 65.
Area is also different.
But you don't see that the point formed perfectly. If it is measured, it will be assumed that the 66 0.65. The total I pray for recovery of khas possession, nothing else.
No, but you
Discourage,
now you did you ask for a recovery from a larger portion. 6.5 acre. Initially, you said it was 0.35 acre, which was mistakenly mentioned in your notice as 6.65. And
Now
in the
the-
schedule also, you said 0.35.
see, but
Now you
when
want to change
submitting,
it.
if I have no ownership, now they have stand in the written statement that is a vested land. They could not produce any document which I have heard from my client also. It is not vested land. But I have to prove. Now, my lord, now my learned friend has stated the evidence has not been proved, but they have also prayed for further evidence. That has been allowed by this order, by this adduced evidence. That has been allowed, and my application has been rejected.
That is on a different context.
That has been allowed only with regard to area. Other matter, that is a type of Mr. Your Lordship, the recovery khas possession was there.
Their recovery of possession suit, it will be delayed. We'll give you opportunity. You will get an opportunity to file additional written statement and also adduce further evidence if necessary. Where is the
That
question
has
of
been allowed.
nature of the character of the suit is not being changed.
Main prayer was declaration. Now main prayer comes for recovery.
Declaration, they want to waive that declaration prayer. They're
Yes.
taking a risk. Because you have clouded their title. If they don't seek declaration, it will be open to you to argue before the trial court at the time of hearing, final hearing. That without a declaration prayer, recovery is not maintainable because you have clouded the title. So let them do damage to themselves. Heard learned counsel for the parties, full stop, by the impugned order, comma, 2 applications were decided, full stop, by the latter portion of the order, comma, an application under section 151 of the Code of Civil Procedure filed by the principal defendant numbers 1 and 2 stroke opposite parties for adducing further evidence was allowed, full stop, whereas, comma, by the comma, whereas by the earlier portion, an application for amendment of the plaint filed by the present petitioner was dismissed. Full stop. The plaintiff stroke petitioner has challenged the earlier portion of the order whereby her amendment application was rejected. Full stop. Learned counsel appearing for the appellant submits that the learned trial judge adopted a hyper-technical approach in dismissing the amendment application primarily on the premise that the same was filed at an advanced stage of the suit. Full stop. Next para. It is pointed out, it is submitted that the amendments sought were innocuous. Next parallel, counsel appearing for the principal defendant numbers 1 and 2 stroke opposite party. You are for the principal defendant. Opposite parties contends that by the proposed amendment, comma, the plaintiff seeks to change the character of the suit property and crucial averments made in the original plaint. Full stop. Whereas the initial suit contained a relief of declaration, comma, the same is now sought to be deleted. Full stop. Furthermore, comma, the description of the suit property is also attempted to be changed by altering the measurement thereof as given in the original plaint. Full stop. Next para. Upon a consideration of the amendment in question, comma, this court finds that there are several aspects to the amendment. Full stop. By the first portion of the proposed amendment, comma, the relief of declaration of title, which was there in the original plaint, is sought to be deleted. Full stop. It is well settled that the plaintiff can, comma, at any point of time, comma, relinquish a portion of its claim. Full stop. Hence, comma, the proposed amendment does not make any major difference insofar as the defendants are concerned, comma, since the deletion of the relief of declaration of title will be at the risk of the plaintiff herself. Full stop. Next para. Even without an amendment, comma, the plaintiff could, comma, at the time of hearing of the suit, comma, have relinquished the claim of declaration of title. Full stop. As such, comma, the said amendment, said portion of the proposed amendment is innocuous. Full stop. Insofar as the alteration of the measurement of the suit plot is concerned, comma, it is found that the rudiments of the amendment are already there in the pleading, comma, since the plot numbers stroke, since the Khatian numbers in question and some of the plot numbers have already been mentioned in the original plaint. Full stop. Thus, comma, the change sought now in the measurement of the said of the self-same plots cannot make any noticeable difference in the character of the suit as such. Full stop. Next para. Thus, comma, the amendments sought are minor and technical in nature, comma, being of a formal character, and the learned trial judge adopted a hyper-technical approach in rejecting the same. Full stop. Next para. I also find from the impugned order itself that the evidence of the defendants is not yet complete and leave has been granted for further evidence to be adduced by the defendants. Full stop. Next para. In any event, comma, the defendants will be at liberty to file an additional written statement to the amended plaint and lead further evidence, comma, if necessary, on the issues sought to be incorporated, on the pleadings sought to be incorporated by amendment. Full stop. Thus, comma, this court is of the opinion that the learned trial judge acted in the exercise of his jurisdiction illegally and with material irregularity in dismissing the amendment application of the plaintiff stroke petitioner. Accordingly, CO number 118 of 2024 is allowed on contest, comma, thereby setting aside order number 57 dated May 17, 2024, passed by the learned civil judge senior division at Jalpaiguri in title suit number 107 of 2015 and allowing the application of the plaintiff petitioner for amendment of her plaint. Full stop. Next para. The amended plaint shall be filed within a fortnight from date in the trial court. Full stop. The defendants, the principal defendants, stroke opposite party numbers 1 and 2 will be at principal defendants, stroke opposite party numbers 1 and 2, as well as the pro forma defendants 3 to 6 will be at liberty to file additional written statement, stroke written statement না এটা এই সেন্টেন্সে কেটে দাও। The defendant stroke opposite party numbers 1 and 2 will be at liberty to file additional written statement addressing the newly introduced pleadings in the amended plaint, which shall be filed within a fortnight after the filing of the amended plaint in the trial court. Full stop. It will be open to the learned trial judge, comma, if need be, comma, to permit both parties to lead additional evidence on the amended portions of the pleadings. Full stop. No address to cost. Next.
Number 6.
Yes.
But I appear for the petitioner, my lord.
Yes, yes,
I humbly praying, my lord, if my lord takes up the matter on Monday, my lord, I will be present before your lordship, my lord.
Yes, Mr. Very well. On the prayer of the petitioner, the matter is adjourned till July 28, 2025. Come back, Mr. Farmer. Yes.
Number 7.
Yes.
Okay, item number 7, I am for the
Opposite party.
but the record that all the record has been received by 2 this morning, Lordship. So I am not got.
Come back. Mr. Datta, give him till tomorrow. On the prayer of the affidavit of service filed to be kept on record, you are appearing for all the opposite parties. On the prayer of learned counsel for the opposite parties, the matter is adjourned for the day. Come back.
Number 8.
Please give the appearance in the previous matter, Mr. Datta and Mr. Raj. Yes.
Item number 8, Lordship.
Yes, Mr. Sarkar.
Till 2 Lordship. Item number 8 and 9 both. I am for the petitioner.
You are asking for?
Adjournment till 2 Lordship.
Till?
2
Why?
So I have some, I could not prepare myself in this matter.
Why till Tuesday?
So,
Come back tomorrow.
Lordship, there are some difficulty. Actually, my son's rice ceremony is
Very well. Yes. Tuesday.
2 Lordship.
Yes, Mr. Ghosh.
Very interesting question of law is involved. I will also get some time to.
No, are you invited in that rice ceremony? Otherwise, it's not interesting.
Invited.
Then it's all right. On the prayer of learned counsel for the petitioners, let the matter stand adjourned till July 29, 2025.
Same prayer in item number 9 also, Lordship.
Number 9.
Same.
Get one.
Item number 10.
Item number 10 and 11 is, I am the petition.
This is appearing for the first time. Motion.
First time motion.
What is the matter?
Item 10, the matrimonial suit and transfer by the prayer for transfer of
10 and 11 should you take up both together? Acha, 10 and 11 টা board action show করে 11 এর file টা দিন. What is the connection between the two?
This 10 is item number 10 filed by the wife against the husband.
Yes.
That has been the matrimonial suit that has been filed before the Siliguri additional district judge, and the wife is residing at Alipurdwar. She claims for prayer for transfer the petition. First of, and second is lordship that has been mother-in-law of the petitioner, that is wife, filed the suit only for partitions, injunction suit against the
husband.
Against the wife, that is the petitioner, daughter-in-law.
Oh, mother-in-law filed.
Filed against daughter.
Mother-in-law filed partition suit and
Partition suit, no. Only injunction. Perpetual
injunction suit and husband, her son filed divorce suit against it.
Divorce.
Very good. Entire family is against it. You are sick. Both are being heard before the same court. Cannot be. Matrimonial must be district judge. But in the same district, both are being. You are seeking transfer of both.
Both.
What is the distance between the two places? Siliguri to Alipurdwar. What is the ground?
Ground lordship and the after the marriage.
The ground of transfer. What is the ground?
She is only she has no income at all, and her father has been looked after the petitioner.
Age of father?
Age of father 78 years. Lordship. And he only some small shop. He has some shop, and that's
so why should he be looked after? He has a shop. So why should he be looked after by the daughter?
because of he is thrown out from the matrimonial. daughter-in-law, the petitioner has been thrown out from the matrimonial. And
Now you are living with your father.
Father, I'm.
So how is that a ground of transfer?
Transfer is the.
Transfer of the suit, why the suit should be transferred?
Transfer is gone, matrimonial suit is like, suit is filed before this Siliguri court.
As a matter of right, you cannot claim a transfer.
No, Lordship.
So what is the ground of transfer?
Travel, because 150 kilometers I have to travel. And I have no capacity to bear this. In spite of that, there is five cases have been filed against the petitioner. Lordship, kindly come to the page number.
Where has it been filed? All in Siliguri.
All in Siliguri. Now, she has been transferred. She has been stay.
Regarding the other three also, you have filed transfer applications. Those have been entertained and stay has been granted. What are the other suits for?
That is only for civil. That is been partition injunction one. Filed by the husband, another filed by the father-in-law. That is been injunction and that declaration. There was 5 suits.
The two applications under section 24 of the Code of Civil Procedure are being taken up together for hearing in view of the identity of the same. Push up in CO number 109 of 2025, the petitioner wife seeks the transfer of a divorce suit filed by the opposite party husband against her at Siliguri to the court of the district judge, learned district judge at Alipurduar. Whereas CO number 110 of 2025 has been filed by the self-same petitioner. Who are the others along with you?
Yeah, my mother, father.
Along with her other relatives for transfer of a suit for partition filed, suit for injunction filed by the opposite party therein, who is the mother of the petitioner's husband, of the petitioner number one's husband. Push up next para, it is submitted by learned counsel for the petitioner that the petitioner has to travel a total distance of 300 kilometers both way between Siliguri to Alipurduar and back in order to conduct the litigations. Furthermore, it is submitted that the petitioner is not in a position to do so in view of her meager financial condition. Next para, that apart, it is argued that several misconceived and frivolous suits have been deliberately filed by the husband of the petitioner and his family against the petitioner and her immediate family to harass the petitioner and her family in view of the pending matrimonial dispute between the petitioner and her husband. In respect of 3 other suits filed in Siliguri, the petitioner in CO number 109 of 2025 has already taken out applications for transfer under section 24 of the Code of Civil Procedure, which have been admitted by this court, and orders of stay have been granted in respect of the connected suits. In view of the above strong prima facie case for transfer having been made out by the petitioner as per the averments in the application, both the applications under section 24 of the Code of Civil Procedure are required to be heard on merits. Accordingly, the petitioner shall serve the petitioner in CO number 109 of 2025 and the petitioners in CO number 110 of 2025 shall serve copies of the applications on the respective opposite parties, indicating that the matter shall be listed before the appropriate learned single judge in the next circuit after the timeline for filing affidavits is over, and shall file an affidavit of service to that effect on the next returnable date. The opposite party in each of the matters shall file their respective affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. There shall be stay of all further proceedings. Now, insofar as CO number 109 of 2025 is concerned, there shall be stay of all further proceedings in matrimonial suit number 13 of 2025 pending before the learned additional district judge, fast track court at Siliguri till disposal of the application. As far as CO number 110 of 2025 is concerned, there shall be stay of all further proceedings in title suit number 38 of 2025 pending before the learned civil judge, junior division at Siliguri, also till disposal of the said application. Full stop, it is made clear that the above order of stay shall not preclude the parties from moving interlocutory applications in connection with the suit. Otherwise, your maintenance application will get affected. Yeah, next.
Keep up.
Thank you.
Number 12.
First time?
Yes, Lordship.
Yes. What is the matter?
Lordship, in this matter, Lordship, the opposite party herein file a title suit for.
Acha, don't write in the cause title petitioner's revisionist opposite parties. What is it? Whether you are plaintiff or defendant in the court below first, say plaintiff stroke petitioner and then defendant stroke. What you are in the trial court, that will come first, stroke what you are here. So unless these are properly captioned, I mean, we have difficulty in catching the matter.
Lordship,
Yes, what is the matter?
Lordship, the opposite party file a title suit for.
Restoration application has been allowed.
Without serving copy.
Restoration application means under order 9 rule 9.
No, nothing has been filed with any permission.
What are you saying?
Yes, Lordship.
What is the impugned order?
Simply just a mere put up petition has been filed without serving copy to us, Lordship.
No, some petition must have been filed.
Yes, Lordship, that is page 18. Without any provision of law, and no copy has been served to us, Lordship. On this.
What is the impugned order? What is the date?
Order number 109, Lordship.
The petitioners have made out a strong prima facie case for the revisional application being heard on merits, inasmuch as by the impugned order, the learned trial judge restored a suit without any formal application being filed under any provision of law, merely on the basis of a put-up petition filed by the plaintiff's opposite parties, despite the suit having previously been dismissed for non-prosecution. Full stop. The revisional application, the petitioners shall accordingly serve copies of the revisional application on the plaintiff's opposite parties, indicating that the matter shall be listed before the next circuit.
Lordship, 30 of July.
Yes.
30 of July in this month. Before this circuit.
Can you serve in between?
Yes, I'll serve.
But it might change my mind on that day.
Whatever it may be, I'll try, Lordship.
On July 30, 2025, when an affidavit of service shall be filed by the petitioners, there shall be stay of operation of the impugned order bearing order number 109 dated November 20, 2024, passed by the learned civil judge junior division Dinhata Kuch Bihar entitled suit number 34 of 2007, as well as stay of all further proceedings of the said suit after restoration till disposal of the application.
Grateful, Lordship.
Item number 13, this matter is led by Senior Counsel Devashish Chakraborty. Is unwell, so praying for Monday. Lord. Is unwell.
Achha.
So praying for Monday.
On the prayer of the petitioner, the matter is adjourned till July 28, 2025.
Great.
Number 14.
Yes, Mr. Lakshman, what is the matter? Why move the matter?
So, Lordship, it is an application under order 26 rule 9, but I'm being led by Mr. Anand Bandari in this case, Lordship.
He is not in court.
No, Lordship, kindly fix it on Monday.
On the prayer of the petitioner, the matter is adjourned till July 28, 2025.
Number 15.
15.
Well, I am for the petition.
Yes, Mr. Chakraborty, what is the matter?
My lord, previously we suffered a decree of my lord eviction and mean profit. Decree, my lord, we have my lord vacated the premises. In the meantime, my lord, a decree for mean profit was drawn up, my lord, to the extent of my lord 39 crores.
All right.
Now, my lord, this decree of mean profit was, my lord, decreed on the basis of my lord the report of my lord valuer Talbot and Company. Now, my lord, when we have challenged by way of a first appeal court, my lord, state, my lord, the operation of my lord, the say of the execution proceeding on consideration of my lord, the deposit of the entire decretal amount. We have
Right.
deposited.
Yes.
Now, my lord, in the meantime, my lord, the second suit has been filed. My lord, we have basically, my lord, the mean profit was, my lord, calculated up to 31st December 2014. Now, present suit, my lord, subsequent suit has been filed for the mean profit from 1st January 2015 up to 31st December 2020, the day on which, my lord, we have vacated the premises. Now, my lord, this decree for mean profit present suit is, my lord, on the basis of, my lord, the valuation of Mrs. Talbot and Company, which is under challenge before in the subsequent appeal.
No,
So
but this is for a subsequent period. Mean profit for a
subsequent period, but on the basis of, my lord, the report of the, my lord, that
But Mr.
particular.
Chattopadhyay, just because you have challenged that it's a ground of your appeal, that does not mean
No,
that.
no, no, my lord, what I am on, my lord.
Yes.
My lord, this, my lord, cause of action, if you lordships kindly come to the page 24 of the paragraph 41 and 42 of the plaint. There, my lord, they have admitted, my lord, that they are, my lord, claiming the mean profit in the present suit on the basis of, my lord, the calculation made by and determination made by Mrs. Talbot and Company, which was my. As page 41, paragraph 41.
I've seen, yes. Talbot and Company.
Talbot and Company. My lord, this Talbot and Company's calculation is under challenge in a appeal.
Right.
And my lord, we have, my lord, deposited the entire decretal amount. Now, if your lordships kindly come to
what was done by the impugned order?
Impugned order, my lord, the suit is now proceeding on the basis of, my lord, the report of, my lord, the valuer of that Mrs. Talbot and Company. Now, presently, my lord, if, my lord, today, my lord, we succeed, tomorrow, my lord, we succeed in the appeal, and Talbot Company's valuation, my lord, goes, this suit will be infructuous. So, my lord, what we have prayed till the, my lord, we have already filed the paper book, my lord, till, my lord, decision of the appeal, my lord, this suit must not proceed.
No, no.
Now, my lordships kindly come to the order impugned.
Yes, yes.
10th April 2025, my lord, last 3 paragraphs. As such, it is submitted that since the matter is already challenged and under consideration before the upper forum, this court does not have any jurisdiction to try the suit at present until further order. Now, my lord, let, my lord, the appeal is already been directed, my lord, to be listed, my lord, after filing of the paper book.
No, Mr. Chattopadhyay, no, no, no. No interference.
No, this is same cause of action. Same cause of action.
Not at all the same.
Yes, my lord. Lordship, kindly see, my lord, page paragraph 41, my lord. The period, my lord, they have.
It's for a subsequent period.
But subsequent period, but, my lord, on the basis of, my lord, the same, they are not praying for the separate, my lord, appointment of valuer. They are proceeding on the valuation.
The valuer, merely because the valuer is the same, that does not mean that the cause of action is the same.
No,
cause of action is for subsequent period.
The basis of the valuation is the same. They are not praying for, my lord, the determination otherwise.
No, Mr. Chattopadhyay, no interference.
No, my lord, 41, my lord, subject to, my lord.
No.
No, my lord, my lord, occupational charges, my lord, they are praying, my lord, on the, my lord, tomorrow, my lord, if court proceeds, my lord, if, my lord, my appeal succeeds, in that event, my lord, this valuation.
If your appeal succeeds, the appeal against the present decree will also succeed. But this is on a different cause of action.
No, my lord, there will be multiplication of the multiplicity of the proceeding.
No multiplicity, no.
My lord, if, my lord, suit is decreed in the meantime, my lord, we have to again challenge, my lord, on the same ground.
No.
On the same ground, because we have already taken a ground, my lord, that the challenging.
Section 10 is not applicable, and this is not an ex debito justicia situation, Mr. Chattopadhyay. No. You have tried your level best. We admit that you have argued very well, but sorry. The present challenge has been preferred by the defendant in a suit claiming mean profits for a particular period for alleged unauthorized occupation of the suit property by the appellant. The defendant stroke petitioner. Next para, learned counsel appearing for the petitioner submits that in a previous suit for mean profits for a different period, comma, the plaintiff stroke opposite party relied on the valuation report of a company by the name of Messrs. Talbot and Company. Next para, the said suit was decreed against which an appeal has been preferred and an order of stay has been obtained upon deposit of on condition of deposit of the entire decretal amount of rupees 39 crore. Full stop. Next para. However, thereafter, the present suit was again instituted against the petitioner by the self-same plaintiff stroke opposite party for mean profits for different periods, but relying on the valuation report of the self-same company, that is Messrs. Talbot and Company. Office of Learned Counsel argues that since the primary ground in the appeal is a challenge to the valuation report authored by the said agency, that is Messrs. Talbot and Company, there would be unnecessary multiplicity of proceedings in the event the present suit is allowed to be continued, since the premise of the present suit is, the valuation report of Messrs. Talbot and Company. Full stop. As such, the defendant stroke petitioners sought for a stay of the present suit till disposal of the first appeal pending against the previous decree, which having been refused by the impugned order, the present revision has been preferred. Full stop. Upon careful consideration of the arguments of learned counsel for the petitioner, this court cannot find any fault or jurisdictional error with the impugned order. Full stop. The learned trial judge proceeded to refuse the stay on the premise that the instant suit has been filed on a totally different cause of action, and as such, the principle of section 10 of the Code of Civil Procedure was not applied. Full stop. Next para. The principle of section 10, the principle as embodied in section 10 of the Code of Civil Procedure is where there is a previous pending suit in respect of substantially the self-same subject matter, a second suit would not be proceeded with. Full stop. However, the period for which the mean profits has been claimed in the present suit is different from that in the earlier suit against which an appeal is pending. Full stop. The mere fact that a valuation report of the self-same agency, which will only be a piece of evidence in both the proceedings, being relied on by the plaintiff does not is not a determinant in the double inverted subject matter, double inverted clause of the two suits. Full stop. Thus, the learned trial judge correctly refused to apply the principle of section 10 of the Code of Civil Procedure. Full stop. Next para. Although it is right law that the court can, in certain circumstances, grant a stay of a suit or proceeding, even if the conditions of section 10 of the code are not met, ex debito justitiae, such a situation has not been made out by the defendant stroke petitioner in the present case. Full stop. As such, this court does not find any jurisdictional error and or illegality in the order of the learned trial judge for this court to interfere with the same, with the impugned order. Accordingly, CO number 128 of 2025 is dismissed, is rejected, is rejected.
My lord, may I submit one thing, my lord?
Yes,
No, my lord, further proceeding, my lord, also kindly make it clear, further proceeding of this, my lord, in present should, my lord, shall be dependent upon, my lord, the outcome of the appeal.
Why should I argue that before the court? Next. Yes. Opposite party, civil division. Yes. So many met criminal appeal. Yes. Mr. Datta is a pure civil lawyer. But no bias in favor of Mr. Datta for that. Yes. What is that?
This is a transfer application filed by the
Wife. Matrimonial.
matrimonial.
Divorce suit filed by the husband.
Divorce suit filed.
What are the grounds?
Grounds is divorce suit, ground of divorce.
No, ground of transfer.
It is the wife is working in Jalpaiguri and is a working teacher in primary school, and the minor child is also studying at Jalpaiguri.
What is the age of the child?
He is reading in class 6. Class 6.
He will be in school the whole day. You go and attend your case.
No, they had filed a.
And you are also working.
No,
So you
they-
don't look after the child the entire day.
No, they had filed also an application under 26 for custody of the and visiting rights. of
So
the-
how does that make a difference, Mr. Datta? Why should it be transferred for them? No, not yet. You take your seat, Mr. Adams. You are threatening the court. Yes.
My lord, actually, what happened in this case? Actually,
No, both of you can't argue. One of you choose. If you start, then I won't hear, Mr. Datta. This is not a relay race sort of thing.
After
The advocate on record is never satisfied with his counsel if the court is against them. So that's a cardinal principle of law. So either of you argue, you choose your arguments. You choose your counsel.
when after it is fixed for PH, about 7-8 dates, they are taken time. The petitioner went there, they are adjourned. on
Sticker 227 direction for early hearing. How does that justify transfer?
No,
Oh, whenever you go, they are asking for adjournment.
adjourned in the 6 dates, continuously, 8. And also that they had filed the custody application and visiting rights, and that minor has to be taken there for visiting.
No, there is a visitation right.
Not, they had not granted, it is not granted,
Then-
they had filed the application.
You are hoping that it will be granted so that it will.
So,
It may not be granted there, it may be granted at your place also. Why do you anticipate that it will be granted? You will have to take the child to the father's house. It's generally the other way around.
no, that,
Custody application pending doesn't mean anything.
no, and this is also PHA is,
No, we can express a hope in our order that suit will be no further unnecessary adjournment will be granted. That we can express.
PH has been, it has
8
been
dates.
shifted from hearing from PH to section 26.
Yes, because
And
they filed that
discussion-
application, obviously. That's the
Yes.
usual course by
Yes,
any court.
That's why it will linger.
Just because it will linger, it cannot be transferred. You are a working lady, he's a working person. So both of you are on equal footing. And this is from Siliguri, where to where?
From Kuchbihar to Jalpaiguri, 110 kilometers away. The minor.
Yes, but you are a working lady, not
Yes.
that you are some person who is.
Is required, the minor child is required for his most of the
You'll
time.
be happy if you're class 6. You'll be happy if he's in school.
All that.
You'll be happy if he's not at home and in school.
All the time he's not, she is not in the school. The school closes on 2 p.m. She comes.
Then you don't come back at that point of time. What sort of what do
Primary
you?
school teacher. He's
What
working.
to come-
at this-
No, that is not. Class 6 is sufficiently mature. If he was a suckling baby, then we could have understood. Or of tender years, say class. We won't mention in class because from the next day transfer applications will be filed if children know that. So anyway,
only-
class 6 is not no transfer. no.
Not that also, so that's all ground.
Kuchbihar and Siliguri,
Jalpaiguri.
Jalpaiguri. Is there anywhere in between?
Yes.
In between? Mr. Bormon is adversely affecting your case. Keep that in mind whenever he appears in some matter. No, is there anywhere in between any court? District court? Name one court. No, we'll just give us a court.
Beckley, Masamanga, they are
District court.
district court, district.
No, district
There are additional district judges there.
Ajay, let us hear her now. These are your grounds, more or less.
Taking time by the.
7-8 times you are.
It's not right, Lordship, because my lord, that.
He has given the dates.
My lord, he has given the dates, but no order sheet, my lord.
Yeah,
in
order
my-
sheet is there.
My petition is incomplete, there is no annexure. My lord, I want to file affidavit in opposition showing that there is no time taken by the husband. My lord, what time, my lord, time has been, my lord, wasted because of, not wasted, Lordship, because of the application filed by the wife under section 24 of the Hindu Marriage Act. Because of hearing of these applications under section 24 of the Hindu Marriage Act, my lord, some dates, my lord, the matrimonial suit became stalled because of that application.
Yes, some of these dates you have also asked for time. OP files a petition paying for time.
He's-
This is on 19th of December, 20th of January. OP files a petition for adjournment, several dates.
And my lord, the matrimonial suit is at the stage of.
If you want to file an affidavit in opposition, we'll plan.
In 19th of December, it is petitioner files petition.
And my lord, the matrimonial suit is at the stage of evidence lordship.
No, order number 19.
Order number.
Opposite party files a petition for adjournment. There are 2-3 dates we have already checked up. So this is an original nature application. Let them file an opposition, Mr. Dutt. You are enjoying stay. Very well.
Next as
Not given. Learned counsel for the opposite party submits that the complete copy of the revision of the application has not been served on her client. Learned counsel for the petitioner is requested to ensure that all the annexes to the revision of the annexes to the application are handed over to the learned advocate for the opposite party during the course of the day. Mr. Dutt, you personally check up that all the applications are, or a complete copy can be photocopied and given. Next paragraph. On the prayer of the opposite party is directed to file affidavit in opposition to the application within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Liberty to the parties to mention before the appropriate bench in the next circuit after the timeline for filing affidavits is over. You are already enjoying stay. Stay was for how? What? The interim order of stay shall continue till the disposal of the application. Mr. Dutt, you personally check up and. Yes.
I'm for the petitioner. This is coming for the first time.
First time. What is the matter?
A similar matter has been decided by your lordship, wherein in an application under Order 23, Rule 3, the order of temporary injunction was relaxed and the petitioner was granted an opportunity to execute a deed in favor of one of the defendants. This is another defendant wherein this has been done. This is another order passed by the same court. And taking cue from the earlier order, which has been set aside by your lordship, this has been passed in the meantime, in the interregnum, taking cue from the earlier order.
No, just remind me, Order 23 Rule 3 between some of the parties only.
The earlier one was Order 22 Rule 3 between the plaintiffs, 3 plaintiffs and the defendant number 5. This one is between the 3 plaintiffs and the defendant number 9.
Same suit?
Same suit.
Have you got a copy of the previous order?
Yes, sir.
So just hand over a copy. I can refer to that. It will be easier for the other side to understand what is the. Learned counsel appearing for the petitioner submits that the learned trial judge has acted without jurisdiction in relaxing a temporary injunction order on the premise of a joint petition filed by only some of the parties, under the guard of invoking Order 23, Rule 3 of the Code of Civil Procedure. Next para. Learned counsel cites an order dated July 21, 2025, passed in CO number 13 of 2025, whereby a similar order passed in connection with the same suit had been set aside. Next para. Since a strong prima facie case for hearing of the revisional application on merits has been made out, the petitioner shall serve copies only 1 to 4.
No, my lord. Defendants, yes, 1 to 4, and the remaining are the pro forma.
Should I direct it to serve only on 1 to 4 or
everyone?
I think that will be easier. Otherwise, someone will come and say you are also guilty of the same thing.
I'll serve.
Yes, the petitioner shall serve copies of the revision of CO number 140 of 2025 on the opposite party numbers 1 to 4 as well as the pro forma opposite parties numbers 5 to 11, indicating that the matter shall be listed before the appropriate bench.
Kindly keeps it on Monday.
On
Tuesday, Monday or Tuesday.
Tuesday so early, how can you serve?
It is local. Every address is local within Jalpaiguri.
Shall be listed on July 30, 2025, when an affidavit of service shall be filed by the petitioner. What sort of interim order are you expecting?
Well, let's stay of that
order.
Yeah, a deed has already been executed. It will serve no purpose.
Uh, Yes, at this stage it will be premature to, well, let it come. We'll consider.
Grateful.
Thank you.
Number 18.
Yes, yes. What is the matter, Mr. Banerjee?
Worship, section 24 application was allowed in favor of the wife, 20,000 rupees per month order was given.
This is appearing for the first time as a motion or no?
No, Worship. It was appeared, the wife, she has filed the opposition. And we have filed a supplementary affidavit giving the affidavit of asset of the wife.
She has filed an affidavit of assets. She also has to file.
She had filed before the court below. We have filed before this court.
No, here also they have to file. Who is appearing for the other side? Somebody appeared on the earlier occasion.
Abhilash Mittal and Sandip.
Give a notice and come back tomorrow. Monday, very well. None appears for the opposite party at the time of call. Fusab, the learned advocate on record for the petitioner is requested to give a notice to his counterpart for the petitioner for the opposite party, indicating that the matter shall next be listed under the same heading on July 28, 2025. When the petitioner shall serve a receipt in that regard. Serve a notice, give a receipt. If they don't appear, we'll take up. Yes.
Yes, Lordship.
Yes. Right.
Matter, Lordship, I must candid with certain facts, Lordship. This.
You are for the other side.
Opposite party.
Yes. What is the yes? What is the candid submission? Yes.
Lordship, in this matter, there is a 4 days delay, Lordship. Matter was filed in the year 2022, Lordship. After that, 2 times notice was served, but unfortunately my clerk misplaced. Third time I have served the notice.
They're appearing.
Lordship, there is another fact, Lordship.
You are appearing for all the respondents.
No, the opposite party number 1, the claimant. The actual fact is that.
May I?
The actual fact will come to action. Let the appellant. Yes.
The award include, that is
Yes.
31st May 2022.
Yes.
Have challenged the said award in the year 2022. But subsequently, the claimant.
Condonation has been allowed.
4 days delayed.
4 days delay we are allowing. Yes, you are Mr.
Opposite party number 1.
You are Mr. What is your name?
Abhijit Raha.
Mr. Raha, we are allowing the 4 days delay, so condonation application.
No, Lordship, there is certain facts, Lordship. But subsequently, the claimant in the year 2023 filed and challenged the same award.
Yes.
That case was disposed of.
Oh, then it has become infructuous.
Yes, Lordship. That is the main.
Been disposed.
That was what he was trying to say.
Yes,
At that
Poor
time-
Mr. Raha was being stopped by the court. Yes.
At that time, actually, we have not received any notice because then insurance company has filed this appeal in the year.
So under Order 4233, the appellate court can pass any decree, even in your favor, could have passed in your favor. So theoretically, your appeal has become infructuous. You have filed the appeal after that disposal.
No.
That was pending. Then this has become rendered same award.
Yes, Lordship.
We'll record that it has become infructuous. We'll condone the delay and say that it is infructuous. Which is the condonation application? 1 or 2? Maybe 2, because subsequently leave was granted. Let us see. Can 2?
2 in respect of stay. I think.
Oh, then 1. Can 1 of 2025 is an application for condonation of delay of about 4 days in preferring the appeal in view of sufficient reason for the delay having been explained?
Lordship, one thing, Lordship, but the grounds of the challenge are different, Lordship.
Let us finish the sentence, then we'll come. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT within bracket MV 24 of 2022. But then you could have taken those grounds. Please, have you got a copy of the Civil Procedure Code? CPC টা ওনাকে দিন থাকবে CPC টা ওনাকে দিন you please come to order for Rule 33. Yes, you can follow the arrows. Under order 14 rule 33, appellate court shall have power to pass any decree, make any order which ought to have been passed or made. You just read out, we'll just.
Or make and pass or make such further orders, decree or orders as the case may be required. And this power may be exercised by the court, notwithstanding that its appeal is as to pass.
Now, if you yourself read, you will not be able to follow. So I'm giving the proper stresses. I'm telling you, the appellate court shall have power to pass any decree and make any order which ought to have been passed. I'm skipping over, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection. So even if you did not file any appeal or objection, in the previous appeal, the court had power to pass a decree in your favor also. And may, where there has been decrease in cross suits or more decrees, exercise be. So therefore, in the previous appeal filed by them, you are the respondent. The appellate court had the power to pass a decree in your favor, the favor of the respondents, despite them not having preferred in appeal. So therefore, the principle of res judicata, or at least constructive res judicata, should apply, because even you had a scope of hearing, you could have raised the points, and court had power to do it. If court did not exercise this power, it has become res judicata then. Grounds may be different, but these grounds were available to you in that appeal also.
But our appeal was previous appeal, Lordship, because we
Decided first, their appeal
Yes,
has been decided
yes.
first, that is it.
Right.
See, if we took the principle of res judicata, first decision prevails. This is not a section 10 scenario. No. I'll record give my reasons. The appeal is taken up for admission hearing. Full stop, next para. It transpires that a previous appeal preferred by the present respondent number 1 against the self-same award has already been disposed of by a coordinate bench of this court. Full stop, next para. By application of the principle embodied in order 41 rule 33 of the Code of Civil Procedure, it was open to the appellate court in the appeal filed by the present respondent number 1 to pass any decree or further decree even in favor of the present appellants, who are respondents therein, despite the said respondents therein not having preferred any independent appeal or objection. Full stop, next para. Thus, by application of the principle of order 41 rule 33 of the code, as well as constructive res judicata, the points sought to be urged in the present appeal could very well have been urged and decided before the appellate court in connection with the previous appeal filed by the present respondent number 1. Full stop. Thus, the adjudication on the previous appeal against the self-same award conclusively determines all issues between the parties in every regard. Full stop. Next para. Hence, the present appeal has been rendered infructuous by virtue of an adjudication on the previous appeal, although by a different party, against the self-same award. Full stop. Accordingly, FMT MV 24 of 2025 is dismissed as infructuous without any orders to cost. Consequentially, is there any other can? Can 2 is there?
It's first aid.
Can 2 of 2025 is also disposed of. No discuss. Sorry. Yes. Boi Perot. Yes. Next.
Number 20.
This is for
Yes.
admission hearing with voting time, final time.
You are for the appellant.
Lots. Application.
You have got a connected application also? No application.
There is a.
We'll just admit it, and
ACR may kindly.
you have instruction to appear for all the respondents, or cannot be? No, this is must be the claimant. Claimant cannot sail on the same boat as the. Let us just check up. No, both are claimant respondent. Oh, owner respondent 3. So you have to put in requisites for service of notice on the owner respondent.
Display service upon the owner because he did not contest.
Did not contest in the. It's easier for him then it will be expedited. Very well. in view of the present appeal being directed against an award under the Motor Vehicles Act and both questions of law and fact being involved, comma, FMET within bracket MV number 36 of 2025 is admitted and shall be heard on the grounds taken in the memorandum of appeal. So, next para. In view of the appearance of the claimants, respondent numbers 1 and 2 through their learned advocate, service of notice on the claimant respondents is dispensed with, full stop. Since learned counsel for the appellant stroke insurer submits that the owner respondent number 3 did not contest in the forum below, comma, in the court below, comma, service of notice of the appeal on the respondent number 3 is dispensed with as well, full stop. Accordingly, the appeal be treated to be ready as regards service, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, which shall be put in within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant, who have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. This is against what? Enhancement?
Challenging the judgment. Not enhancement, we are challenging the award itself.
Award itself. On merits.
Merits.
Thanks.
Item number 21.
This is also within time. We have to start, Nani said.
He's not appearing in this matter. Very well. Then you, in view of questions of both law and fact being involved, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. The appellant shall put in postal costs and due requisites. Owner respondent appeared.
No, not at
Postal costs and requisites for service of notice of the appeal on the respondent number 1. Full stop. Respondent number 1 within a week from date. Since learned counsel for the appellant submits that the owner respondent number 2 did not contest in the court below, comma, service of notice of appeal on the said respondent is dispensed with. The appeal, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop, liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Next.
This is also within time. Owner did not contest.
Last matter is order holo ekdom last matter ta just ageta seta same.
Great.
I'm for the appellant.
Yes.
23. Can it be taken up on Monday, Malad? I could not make myself ready.
Monday, Mr. Chair, I won't be able to conclude and pass judgment then. Is it a short point?
But the issue is very short, limited.
We can hear Mr. Rahman today and come back tomorrow, Mr. Yes, yes. Burn midnight oil.
Mr. Shivashish Ghosh is also there. He is leading.
Mr. Shivashish Ghosh will appear.
He's leading me, my lord.
He's leading you. Then if he's ready, then we'll. Yes, Mr. Ghosh. Mr. Ghosh, we know you are technically challenged, but you must unmute yourself and the video should be seen.
Usually part of sealing is.
No, Mr. Ghosh is absolutely technically challenged. I know, personally know. So let us start hearing the appellant. What is the difficulty? What is the appeal about?
I filed a suit for the plaintiff and for the plaintiff.
If it's very short, then if it ends as soon as it starts, then let us adjourn it for some other day. What is the point involved? Just
the point involved that the first appellate court did not even appreciate the evidence on record and proceeded on certain erroneous conclusions regarding some errors made in the plaint, taking that to be sacrosanct, passed and passed.
Did not look into the evidence.
Yes, the decree was passed in my favor by the trial court, but subsequently the first appellate court reversed the decree on those grounds. My lord, find the relevant page. My lord takes up the impugned order.
My lord, what may I just?
Yes.
The suit was decreed on the ground that the plaintiffs who have derived a title by way of purchase from a gentleman, Muslim gentleman, my lord, who was a resident of Kuch Bihar, and before 1980, the Muslims of Kuch Bihar were guided by the Daya Bhaga school. And
I did not know that.
And that is
Yes.
because of the princely state of the.
Yes, because of the Maharaja.
Because of the Maharaja.
And they could have opted to be
The
guided.
opposite of Kashmir.
They had an option, yes.
Yes.
They had an option, but that option had to be executed in writing.
Executed in, but.
Option was taken.
Option
And,
was not taken. That option had to be executed in writing, and only those persons who were.
So then they are not governed by the.
Then they are governed by the school of.
My lord.
If they don't take the option,
If being Muslims, they executed the option.
if
then
they
would be
take
governed
the
by
option that they'll be followed by Muslim law,
Sharia,
there.
Sharia, Muslim person.
Then they did not opt, so they are
They
governed
would be
by
governed by
Daiva. It becomes easier.
Hindu person.
Because Muslim law succession is very difficult for me, for you also, everybody.
I have no idea.
No.
So my lord, what happened? That,
Oh, you can calculate that for us.
Yes.
yes, he can.
I'll have to learn from you then, in some matter, whenever the chance comes.
What I have heard, my lord, his senior was a renowned civil practitioner here, especially.
No, all
in
the
law.
previous people knew,
So-
but I am not confident. Yes.
So what happened, my lord? The plaintiff, my lord, challenged and said that since they were governed, the seller was governed by the Dayabhaga school of law by way of inheritance. Some of the legal heirs of that gentleman had also sold some properties to the plaintiffs. And defendant number one was the daughter of that particular individual. So the point was that the daughter.
Their vendor sold some of the property, some of his property to him, to them, and the rest you claim by inheritance from the vendor.
Inheritance, female persons, but if the
Female-
Dayabhaga school of inheritance is
Yes.
applicable, then the females would be excluded from the
That is what the,
inheritance.
that is what the learned trial court held.
No, females should be excluded.
Excluded.
That is what the
At that
trial
point
court.
of time, it was females. were
Which point of
Which
time?
point of time I
But
also.
that's in 1975.
75, they are not
No,
excluded.
they were excluded because by virtue of the laws applicable therein. It was the personal law. It was not the Hindu Succession Act or the.
No, it was a
all of that
Dayabhaga
comes
school of
applicable.
law, my lord.
If it's Dayabhaga school of law, there is a different law, succession act there.
But
No,
what happens is that
If Dayabhaga school is applicable,
but
then normal law applies.
there's a judgment of the honorable of this High Court,
That-
wherein it was stated that this Muslim personal law would not be applicable to those persons who are even Muslims but who have not selected opted. for that.
Dayabhaga school.
And
Dayabhaga
they-
school.
it is also stated in that judgment. That judgment is being followed. That's the judgment of 1921.
Yes.
Produced that judgment.
What does he say?
Well, when it is stated that the female what is all the would be prevented from claiming inheritance on the basis of that particular. If they are
Why
governed by-
Hindu Succession Act is not applicable?
no, Hindu Succession Act is not applicable.
What is the law applicable?
That is the old Hindu law. That was prevalent there.
No, but
Why in 1975?
Codified, not the codified. Codified law did not come.
No,
into
the
force.
moment the Hindu Succession Act came
It
into
was the
force.
State of Kuch Bihar. That is the reason.
This is very interesting.
It was made applicable at a subsequent point of time. That judgment
Very
which I am referring to, my lord, that judgment clearly states when it was made applicable.
You refer to the citation to him so that you
Yes,
can come
I will
prepared.
Which-
81 Calcutta, 81.
You know the judgment.
I have
It's already stated.
So we can take up the hearing then if you are ready.
not
You are ready, fully
that
ready.
I am ready with the facts, my lord. But
You're
not-
ready with Dayabhaga, you're ready with the 51 judgment, what
So, then,
remains?
my lord, we just continue.
Then you can take up the hearing.
By that time, my lord, my senior will also.
No, I'm not confident of
If
that.
it is taken up on Monday, then it would also be a little more helpful for me because I would be able to bring the judgment.
Very well, then we'll take it up. On the prayer of the
Joint prayer.
on the joint prayer of parties, the matter be adjourned till July 28, 2025.
My lord, may I give Mr. Ghosh's name?
Mr. Shivashish Ghosh.
Name was there.
No, he has appeared online, yes.
Good.
Yes, injunction appeal,
No, my lord,
Remand.
it is MSCT,
MSCC,
my lord.
who is for the other side. Give a notice to the other side and come back.
My lord.
I think that will be better.
I have served,
No, just nobody is appearing for them.
nobody has done.
No, the application, you are moving an application or for the first time for admission,
Admission already completed.
completed. Then you-
Paper books submitted,
Oh.
paper books service also completed,
No, acha, service completed.
my lord.
Yes, Mr. Bormon, you had some instruct.
Royal Insurance Corporation. Royal
Take
Insurance.
instruction, Mr. Bormon, and
Probably
You-
first case of company before the circuit. Royal General Insurance Company? or-
Yes.
Yes, divisional manager, Royal Insurance Corporation. You generally appear for Royal Insurance.
Royal-
No, must be same. Let us see.
Hey,
Of Bhutan.
Oh, Bhutan, that's separate. No.
You are of India.
We are really not agreeing in any, before the trial.
Oh, whether we don't know, we are not confident whether service has been properly effected through the embassy.
I have to serve through the embassy.
You have served through the embassy.
Through the embassy.
Where is that? I mean, where do I get that?
My lord, the track report is there.
কোনো ইয়ে আছে? No, no, you did not, you had to serve through the court. It has to be posted, you had to deposit postal cost. It has to be served through the court. You cannot directly serve. No, that has to be done. Affidavit of service is here. This was regarding the application. Oh, the appeal itself you have served. Paper book. No, service has to be effected through the, you have not been given anything, or this is for enhancement? You have received some compensation.
No, I have not.
Totally rejected.
Awarded, but not interest was given, and the filial
So you have got some amount. I mean, you serve through the court. This service is not. Although from the affidavit of service, it transpires that the appellant has served a copy of the paper book on the respondents, comma, I do not find from the records that a formal service through court has been effected. Push up. Accordingly, the appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents, comma, within a week from date. Push up. Let the matter go out of the list for the present, upon with liberty to mention as and when such service is completed. You just inquire from the department as to what would be the postal cost, because they also have to serve through embassy, but then it will be formal.
In this case, Lordship, I am appearing on behalf of the insurance company, Lordship. This matter is, I have mentioned the matter which your Lordship has tagged with. my
Oh,
appeal.
yes, she has mentioned that morning.
Sir, I'm giving paper.
Paper book, give paper book, yes.
Maybe
You also exchange the paper books and all. So Monday,
Monday.
what is the number of the other appeal?
Most of 79.
Just give us the number, I'll put it in my order, that's why. Let the appeal be listed along with blank on July 28, 2025, comma, since both the appeals are arise out of connected matters. You give that number. You can just write it on a piece of paper and hand over to my officer so that he will just be able to.
Insurance
Huh?
আমি দেখছি আমার কাছে লেখা।
Yes, yes. In either of you write it on a piece of paper, the other number. Next.
I'm his matter also, he is also appearing, so it may be hard contested way. So he's appearing and he's saying that Wednesday would be better for him.
Otherwise, it's ready for hearing.
Yes. Lordship, one order has to be in both matter. To be
In this one
recorded.
and which one? 25 and 26?
25 and 26, both. She is in 25 and he is in 26.
But 25 we have fixed on Monday.
Monday and 26 is on, it may be fixed on Wednesday. Separate matter, this is separate matter.
You are saying one model will.
One in there is, that is service of paper book upon the owner respondent we discussed.
No, did he contest in the trial court?
No, that is it.
In 26 or both the matters? 25, please check up whether the owner respondent.
Yes, I have checked.
আচ্ছা তাহলে 25 26 এ যা বললাম 25 এ যা বললাম তার সঙ্গে অ্যাড করে নাও যে learned counsel for the appellants submits that the owner stroke respondent did not appear and contest in the court below. So accordingly, service of notice of the appeal on the said respondent is dispensed with. Push up in view of the contesting respondent having already appeared through counsel, comma, the appeal be treated to be ready as regards service. Our 26-এ যেটা বললাম সেটাই সার্ভিসের রেসপেক্টে যেটা বললাম সেই ওনার এটুকুনি এটা করে দাও। তারপরে বলো on the prayer of learned counsel for the respondent, let the matter stand adjourned till July 30, 2025.
Get the, my appeals number.
ঠিক আছে তো? ওটা ঢুকিয়ে নিও আগেরটা 25-এ, ওটা 25-এ।
কোনটা? না না আমাদের ট্যাগ হবে 79।
Tag হবে 25
অ্যাডমিশন হয়ে গেলে নাম্বার এখন অর্ডার শিটে 29 দিদিছো